Okay, please be seated. All right, so we are back on the record without the jury being present in State of Ohio versus Deshawn Stafford and Tyler Stafford. When we concluded last evening, the state had rested its case with the exception of introduction of exhibits. So at this time, Ms. Schucke or Mr. Kuhn, go ahead with exhibits. Counsel for the defense, if you have objections to any of the exhibits, just jump in. We're not going to go one by one. Okay.
So just first off, I will read the numbers, but there are the different videos that we had, body cam, scene video, and Defendant Deshawn Stafford's interview. They are all on a thumb drive, individually marked with their exhibit numbers on the icon, I guess. So the first one, states Exhibit 1, is on the thumb drive. That is the body camera video of the first responding officer. That was Kyle Walter. Do you want me to read them? Are you going to object as I go, or?
Just jump in with an objection
Okay.
if you have one.
Fair enough. All right, then states 2 through 25 are all crime scene photos as introduced and authenticated by Sergeant Miller.
Okay.
Just trying to pull those out. Okay. States 26 is the crime scene video on the thumb drive. States 27 is the CSU photographs of the victim's car, the Kia, as it was processed, also on the thumb drive. States 28, photograph from the crime scene. 29 is also on the thumb drive. That's the I Promise School parking lot raw video footage. Exhibit 30 is the I Promise basketball court raw footage. States 31 is the McDonald's drive-through in the dumpster area raw video footage. States 32 is the McDonald's camera facing Market Street raw video footage. And States 33 is the compilation video that was about 7 minutes and 45 seconds in length. All of those videos are on the thumb drive. States 30.
And that's the end of the thumb drive, so 1 to 33 are on the thumb drive. Okay, let me know when we're done with the thumb drive.
Okay. 35 is the...
I'm sorry, I think, did you skip 34?
You're right, I'm sorry. That's a photo of Ethan Liming. So then 35 is the splat ball gun recovered from 515 Howard.
I want to see that.
It's right here. It's the one you guys...
Oh, I thought it was, you're going the actual
Sorry,
weapon.
the actual
Okay.
splat gun, yes.
Sorry.
And then 36 is the container of the gel Orbeez found in the car, Ethan's car. 37 is the 911 call from Stefanko. That is on the thumb drive. 38 is the Summit County Medical Examiner's report of investigation. 39 is the Summit County Medical Examiner's report of autopsy. 40 is the Summit County Medical Examiner's PowerPoint. That's on the thumb drive. 41 is a still from body camera by Officer Mobley. And, sorry.
Okay, that's
41.
fine. Yep. Thank you.
42 is another still from the body cam from Officer Mobley.
Object, is that the paintball gun? Yeah, we have objected to that one. Yeah, I would object to that one. That appears to be a photograph taken several days after this incident where the police officer went in to pick up an Orbeez gun that's in a bag, and it just so happens that there is a paintball gun that has no relevance to this case, that is positioned directly in front of the Orbeez gun.
Jenny?
The Orbeez gun is in the back of a plastic bag.
So it doesn't really have any evidentiary value because no one's contesting it as an Orbeez gun, but there's no purpose in putting a paintball gun that apparently belongs to the defendant's girlfriend's brother other than to imply somehow that these young men are dangerous.
That wasn't the point at all. That was to show where the splat ball gun was located when picked up by the officer.
which isn't an issue.
And Your Honor, it's not even visible. It's in a plastic bag. You can't even see entirely what it is. And it's up in the corner. It's just amazing that of all of the body camera footage, something's taking hundreds of photographs in a minute or an hour. This is the one that was pulled out and used, where you can't even see the splatter ball gun that's relevant, but there's a paintball gun that has nothing to do with this case. It's right in the center of the photograph. It's pretty obvious that it's...
It looks scary.
Your Honor, if I could briefly respond. Your Honor, one of the issues that was presented here throughout the trial by the defense through their line of questioning was to try to establish essentially that it was completely unfathomable that Ethan and his buddies would have toy guns essentially, and that you don't play like that in Akron, and that it's just completely preposterous to have a pretend gun or some sort of toy gun, and that it would be something that the Stafford brothers would be unfamiliar with. And I believe it does have relevance there, Judge, to demonstrate that, in fact, Deshawn did have a paintball gun, not only in this photograph here at his home, where he lives, but also I anticipate the defense will object later on to the image that they objected to yesterday regarding the image of a different paintball gun in Deshawn's car at the time that it was, I'm sorry?
We should pull that out and do it.
Okay.
Let's do a vote.
That's, looks like states Exhibit 48, Judge, if I can approach and present that to the court.
Okay, and 48 is in Deshawn Stafford's car when it was taken and inventoried, et cetera.
I believe so, Judge, yes. I believe that was June 11th.
And Judge, I'm sorry to jump in. 48 is where it was shown to the detective, and he said, yes, this has no evidentiary value. And the prosecutor said, no, it has no evidentiary value, but we're marking it as an exhibit. But we know it has no probative value whatsoever.
And there's been no testimony that actually ties these boys to it. And we know that the guns found at the girlfriend's house is her brother's. No one's testified that Deshawn or Tyler knew about it. And the one that's found in Deshawn's car is found in the back seat apparently a week later. There's no testimony that that's his paintball gun and he uses the paintball gun. Even if there was, that's not relevant to this.
Judge,
It's just jury's up the jury. Jury's up the question for the jury.
Judge, Attorney Gallagher's statement is not quite right. He mentioned this yesterday. The detective indicated that nothing of evidentiary value was taken from the car there. He did not comment on the relevance or evidentiary value of that photograph, Your Honor.
All right, so I think as to 42, there's no evidence that this paintball gun belongs to Mr. Stafford, et cetera, and the relevance of it is tenuous, to say the least. I think there's, as to Officer Mobley's testimony, he went there, he got a paintball gun, they gave it to him without incident, and he left. I'm not going to admit 42. 48, that was in Mr. Stafford's car, along with the basketball, along with some other miscellaneous items. I don't think there's been any dispute that that's a paintball gun, that no one has said or implied that that's a real weapon. That is the condition of the car when it was taken in. I will allow 48. So we'll go back to 43, I guess.
43, yes, Judge. That is the interview of Deshawn Stafford. It is on the thumb drive. 44 is a photo of the Akron School parking lot from Sergeant Miller's body cam. 45 is a similar photo from Sergeant Miller's body cam of the parking lot. .46 is the picture of the defendant's, Mr. Stafford, Deshawn Stafford's front of his vehicle, showing the damage to the vehicle. 47 is another photo of his vehicle from the passenger front side, showing the damage closer up. And 48 then is the one you just talked about that you admitted, the picture of the car, the interior of Deshawn Stafford's vehicle when it was inventoried.
All right, so exhibits 1 through 48, with the exception of 42, will be admitted. 48 will be admitted over objection. Any motions?
Your Honor, pursuant to Ohio Rule of Criminal Procedure 29, at this time, on behalf of Defendant Deshawn Stafford, I will move for a directed verdict of judgment of acquittal on all charges. I recognize that it's unusual, to say the least, for a court to take this decision away from a jury when we are this close. It would be that unusual, exceptional case. This might be that circumstance. This might be that circumstance, especially as it relates to count 1, the involuntary manslaughter by way of aggravated assault. We've got some real issues. The state has some real issues with causation. In order to find my client guilty, a jury would have to find beyond a reasonable doubt that he caused the death of Ethan Lyman. When we started out here, maybe that was just assumed, but that is no longer a safe assumption. There's been ample evidence that somebody else was involved in this, namely Donovan Jones. That Donovan Jones may have been the aggressor, at least as it relates to the boys involved in their response to Ethan and his friends. And when it comes to causation, and when it comes to serious physical harm and the deadly force required, none of that's been proven. All the assumptions we had early on kind of fell apart with the state's case. At this time, Your Honor, I'm asking this court to take these portions of this case, specifically the felony 1 aggravated assault and the felony 1 involuntary manslaughter by way of aggravated assault, the felony 3 involuntary manslaughter by way of assault, and I'm asking to direct those out. There's not sufficient evidence to send those to a jury. At most, what you send to the jury is what Donovan walked away with, which is the misdemeanor assault charge. Thank you.
Mr. Gallo.
Your Honor, I too would make Criminal Rule 29 motion for a judgment of acquittal. It's a 2-part motion. The broader concept is, under the new law, the prosecution is required to show that there was any act that Tyler Stafford made was not self-defense. I don't feel that they've done that. If he was acting in self-defense, they haven't proven otherwise. That's the broader part of the motion. There's a more specific, tailored, the second part to the Criminal Rule 29 motion, and it goes to the 3rd-degree felony involuntary manslaughter. Specifically, looking at the indictment and also looking at the bill of particulars that we were able to obtain. It's a rather lengthy bill of particulars, but I would say what we used to call the 2-wit would be in paragraphs 7 and 8. And in paragraph 7 and 8, they're talking about Deshawn Stafford, Tyler Stafford, and then in paragraph 6, Donovan Jones engaged in a fist fight with Ethan Lyman. Paragraph 8 says that Ethan fell backwards from the blow, hitting the back of his head on the pavement. He was knocked unconscious and died from his head injury. So the person who caused this head injury is the person who is potentially responsible for involuntary manslaughter if it's not a self-defense act. We heard from the medical examiner that the injury to the back of the head was the cause of death. Everything else, although horrible, is not relevant to the charge of involuntary manslaughter. There's been no testimony that Tyler Stafford did anything to cause Ethan to fall backwards, to hit his head. There's no testimony that Tyler Stafford slammed him to the ground. We heard testimony from one witness that Deshawn Stafford hit him and knocked him backwards. We heard testimony from 2 others saying that it might have been Donovan Jones. We heard no testimony of any kind that Tyler Stafford did anything to cause the death of Ethan Lyman. And going on what our notice comes from the indictment and from the bill of particulars, specifically paragraph 7 and 8, that was not proven. There was no testimony to this. The only thing we had was from Detective Hornacek at the end. And he said, well, there was a statement all 3 jumped him. Like all 3 are responsible for the manslaughter. Well, that's not in the indictment. That's not in the bill of particulars. So we're relying on this bill of particulars to tell us what the legal theory is, what the allegations are, how to defend ourselves from the facts of the law. There was no testimony backing up this bill of particulars. So we're making a broader Rule 29 motion on self-defense for both of Tyler's charges, but very specifically to the third-degree felony involuntary manslaughter. Causation and proximate cause, they're just not there.
Your Honor, and I'm sorry, I want to adopt Attorney Gallick's the argument you made for Tyler. I want to adopt that for Deshawn. I never got past cause and whether or not Deshawn even caused this in my argument, but really for the state to prevail, they've got to prove, there had to be evidence that Deshawn did not act in self-defense. There had to be some evidence of that. They got to prove that to this jury. We never got that far. There's been no evidence that would establish that Deshawn was not acting in self-defense. We heard from no one that said anything contrary to that. There's no way that the jury can find that Deshawn didn't act in self-defense because no evidence was presented to that. And that's the effect of the new law, and that's the burden shifting. So I just said in my opening argument here, Attorney Gallick brought it up for Tyler, and I brought it up for Deshawn. I think that's a powerful point. Thank you.
On behalf of the state.
Thank you very much. Your Honor, just very briefly, may I please support. Your Honor, the state does believe that we have met our burden in terms of presenting our case to the jury for their consideration. Regarding Deshawn Stafford, he does have the involuntary manslaughter by way of aggravated assault. The state does believe that the evidence presented is enough for the factual determination to be made by the jury regarding causing serious physical harm to the deceased Ethan Liming, and that his death did occur and was caused by that aggravated assault. Additionally, the state does believe that we have met our burden regarding essentially the lesser count of involuntary manslaughter by way of misdemeanor assault in the event that the jury were to find that the facts would play out that Deshawn did not cause serious physical harm and just find that he did assault Ethan Liming. The evidence was quite clear, Your Honor, that this was not a situation of self-defense, that this was in fact a brutal attack, initially by Deshawn, an older young man, and then ultimately with his brother and cousin joining in, ultimately creating a 3-on-1 fight situation. That did cause the death of Ethan Liming, Your Honor. Additionally, we did prove that that was on June 2nd of last year here in Summit County, Ohio. Additionally, Your Honor, regarding Tyler Stafford, the state has met its burden there as well regarding the involuntary manslaughter by way of assault. Evidence presented by several witnesses and statements of the defendants themselves indicated that they weren't actively engaged in a fight with Ethan. Really, to call it a fight, Your Honor, is insulting. It was not a fight. It was just an attack. The evidence did show that Ethan was ill-prepared to fight anyone. He was playing with a toy, and the evidence did show that his shoes ended up strewn about in the parking lot as he was pummeled and moved some distance away throughout that event by 3 individuals, primarily by the Stafford brothers. That did cause his death. Additionally, Your Honor, related to the points brought up by Attorney Gallick, the state does believe that there is evidence sufficient to show that there was a common scheme here and that the defendants were acting in concert with one another by engaging in a fight, at least 2-on-1 or 3-on-1, and the state has met its burden in proving those elements and putting this before the jury, Your Honor. That's all we have right now.
Okay, thank you. Mr. Gallick?
Judge, I got to say, acting in concert, I didn't hear that in the opening statement. I didn't hear that this was some kind of conspiracy to commit a homicide. It's not the indictment. It's not the bill of particulars. It wasn't the testimony of any of the witnesses. So, obviously, I'm supporting both parts of my criminal Rule 29 motion, but as to the involuntary manslaughter for Tyler Stafford, we didn't have any testimony of anything like that. We didn't have any testimony that there was some common scheme that the prosecutor just brought up. There's some conspiracy, the 3 of them working together to try and commit a homicide. there's no testimony that Tyler Stafford did anything to cause the death of Ethan Lyman. So we would ask that the third-degree felony, the judgment of acquittal, be entered into that charge at a very minimum.
Okay, thank you. So I agree that there are numerous factual issues here. There is conflicting evidence related to some of those facts. However, taken in a light most favorable to the state, there is evidence that has been presented related to each of the elements of the case sufficient to send these charges to a jury. As to Mr. Gallup just referred to it as conspiracy. I don't think it's conspiracy. It's a complicity argument. The complicity argument does not change the charges that have been presented through the indictment and the bill of particulars. It does change the theory somewhat. However, it is within the discretion of the court to allow that. So I will overrule and deny the Rule 29 motions. That takes us to the jury instructions. Counsel and I have spent considerable time last night and this morning discussing jury instructions. I believe the only one that is in dispute, the state has requested a complicity instruction related to Tyler Stafford and count 3. Counsel, did you want to address that?
Yes, please, Judge. I do appreciate the court and your staff, as well as the defense working with us to try to clarify the issues contained in the jury instructions that will hopefully be presented to the jury here shortly. Your Honor, the state does believe that a complicity instruction would be appropriate here, perhaps related to aiding or abetting, or an alternative. I believe it's soliciting the aid of another. As it relates to Tyler Stafford and the felony 3 involuntary manslaughter count, the state does believe that that would be appropriate based on how the testimony and the evidence did come out of the trial here these last several days. Ultimately, Your Honor, it is within the court's discretion. However, the state does not believe that it has changed anything or significantly alter the theory of this case, Your Honor. The allegation all along was that there was an incident whereby the Stafford brothers and their cousin attacked Ethan Lyman, and that there was yelling going on. That is essentially what played out through testimony here this past week, Your Honor. The specifics of it in terms of calling a name may be slightly different. However, it is not a significant difference and would not ultimately affect the way this case would have been defended from the state's vantage point. And the defense was on notice of these general allegations, Judge. Thank you.
I would object to that jury instruction. I was notified today that that was the theory. I did not know that Tyler Stafford was being accused of calling his brother's name and that caused the manslaughter. So we would object to any instruction as to Tyler Stafford on aiding and abetting or conspiracy or complicity or any of those other novel theories that were not really known to us until today. We object to any jury instructions on that.
As it relates to Deshawn and joining that argument?
Well, again, I think there is evidence that this was a 3-on-1 altercation, at least at some times during this incident, and that in and of itself could be an aiding and abetting situation. So I will give the complicity instruction as requested by the state. State has rested. We may repeat this in front of the jury, but as to the defense's case.
I'm sorry, Your Honor, can you repeat that for me?
So I'm turning to you to ask if there is any evidence on behalf of the defense.
1 second, Your Honor. Your Honor, at this time, the defense is going to rest on the burden of proof. Thank you.
Mr. Gallick?
We would also rest our case and renew our criminal rule 29 motion.
Renew it for Rule 29 as well.
First of all, Mr. Deshawn Stafford, Mr. Tyler Stafford, I just want to confirm that you have conferred with your counsel related to your right to remain silent, your ability to testify, and that it is your choice at this time not to take the witness stand and testify. Deshawn? Mr. Tyler? You need to, thank you. All right, and then I would also deny the renewed Rule 29 motions. When we reconvene in front of the jury, I will ask the defense to just rest on the record in front of the jury.
Your Honor, as I stated yesterday, and I don't follow your instructions certainly, I do think that it's not necessary for the defense to rest in front of the jury. You're resting for the record. I think the jury should just be told they've heard all the evidence they're going to hear. I think it draws inference that the defendants did not testify. That would be a violation of their rights not to permit themselves or not to testify in their own case.
What I concur.
All right, I have done this outside the presence of the jury just to get the Rule 29 motions done in an efficient manner and not have to move the jury in and out several times in the course of about 5 minutes. So I think I'm doing this for just time reasons. Generally, you would need to rest in front of the jury, and I will just ask that question. I don't think it makes any inference at all, and they will be instructed in the jury instructions related to the defendant's right to remain silent. Okay, can I see counsel briefly? Recess and check on a couple things, and then we'll go forward with the jury.
use for closing.
Or indicate how long we would be in recess. Shit.
Jury instructions are very long, and she has to read all those first. So we'll probably. Yep.
Okay, folks, just a reminder, when the court is in session, no cell phones, turn them off. And please be seated to the narrator.
and gentlemen, I do apologize for the delay getting started this morning. As I discussed yesterday, the lawyers and I had some things we did need to accomplish, and hopefully now things will go a little bit more fluidly for the rest of the day. When we concluded yesterday, the state had rested its case, and therefore I'm going to turn to the defense for any evidence that the defense may wish to present. Mr. Sin?
Your Honor, on behalf of Defendant Deshawn Stafford, we are going to rest on the stated evidence. Thank you.
Thank you, Mr. Sin. Mr. Gallick?
Your Honor, at this time we would rest our case.
Okay. Would note for the record the renewal of the Rule 29 motions that we did discuss on the record previously. Okay, ladies and gentlemen, then I will tell you what the plan is here for the rest of the day. I am going to begin with some jury instructions for you. I'll give you part of them related to the charges, and then at that point we will break for lunch. I'm anticipating taking maybe a little shorter lunch than we have in the past. Then following lunch we will proceed with the closing arguments of counsel, and then I will have some further jury instructions for you related to how to conduct your deliberations. So I do have the jury instructions related to the charges that I will give to you now. I will tell you that you are free to take notes through the reading of the jury instructions. However, you should know that you will have copies of these, written copies of these with you during your deliberations, just so you don't feel like you have to write down every word that I'm saying. You can refer to them later. You have now heard all of the evidence of counsel, and it is my duty to instruct you as to the law that applies in this case. The court and the jury have separate functions. You decide the disputed questions of fact, and the court provides you with the instructions of law. It is your sworn duty to accept these instructions and to apply the law to the facts as you determine those facts to be. You are not permitted to change the law or to apply your own ideas as to what you think the law should be. A criminal case begins with the filing of an indictment accusing or charging the defendant with committing a particular crime. It is important that you understand that the filing of the indictment or the indictment itself is in no way to be considered by you as evidence against the defendant. The filing of the indictment informs the defendant that he has been accused of the offense. The plea of not guilty is a denial by the defendants of the crimes that are charged and puts at issue all of the essential elements of the crimes charged. The defendants are presumed to be innocent until their guilt is established beyond a reasonable doubt. The defendants must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the crimes alleged. I am now going to define reasonable doubt for you. Reasonable doubt is present when the jurors, after they've carefully considered and compared all of the evidence, cannot say they are firmly convinced of the truth of the charges. It is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. I will now define evidence for you. Evidence may be direct or it may be circumstantial or a combination of the two. Direct evidence is testimony given by a witness who has seen or heard or felt certain acts or facts to which he or she testifies. Direct evidence includes exhibits admitted during the trial and any stipulations by the parties. Evidence may also be used to prove a fact by an inference. This type of evidence is called circumstantial evidence. It is the proof of facts by direct evidence from which you may infer other reasonably related facts or conclusions which naturally and logically follow according to the common experience of mankind. Whether an inference is made rests entirely with you. You may consider both direct and circumstantial evidence. You must decide from all the direct and circumstantial evidence taken together whether the state has proven all of the elements of the charged offenses beyond a reasonable doubt. The evidence, as I have said, does not include the indictment. It does not include the answers to questions you were instructed to disregard or the opening or closing statements of counsel. The opening statements and closing arguments of counsel are designed to assist you, but they are not evidence. You must not speculate as to the reason why the court sustained an objection to any question or what the answer to that question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. The different varieties of evidence you have heard throughout trial are as follows. The first type and the majority of the evidence you heard in this trial is what we call testimonial evidence. That was where a witness took the witness stand, testified to facts they had knowledge of or had observed. You as jurors have the sole and exclusive duty to decide the credibility to give the witnesses. In determining that question, you will apply the tests of truthfulness that you apply throughout your daily lives. These tests include the appearance of each witness on the stand, their manner of testifying, the reasonableness of their testimony, the opportunity each witness had to see, hear, and know the things to which they testified, their accuracy of memory, their frankness or lack of it, the intelligence, interest, or bias, if any, together with all the facts and circumstances surrounding that testimony. Apply these tests and you will assign to each witness the weight that you deem proper. You are not required to believe a witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. You should decide what testimony is worthy of belief and what testimony is not worthy of belief. Normally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. It is not necessary that a defendant take the witness stand in his own defense. The defendants have a constitutional right not to testify. The fact that the defendants, Deshawn Stafford and Tyler Stafford, did not testify must not be considered for any purpose. The second type of evidence admitted during the trial is real or demonstrative evidence. For example, this is a pen. If for some reason this was admitted in trial and had some relevance to the case, you'd be able to take it to the jury room, look at it and see what it is and see if it works and give it whatever weight you deem proper. Real evidence could be pictures, in other cases maybe drugs or a number of different things. It is any real object that was admitted during the trial. A number of exhibits and the testimony related to them have been introduced. You may consider whether the exhibits are the same objects and in the same condition as originally taken by the police officers, and you will determine what weight, if any, the exhibits should receive in light of all of the evidence. The third type of stipulation is what we call the third type of evidence is what we call a stipulation. Stipulations are nothing more than facts that both sides have agreed are true. I'm now going to go through the various counts of the indictment. In count 1, the defendant, Deshawn Stafford, is charged with involuntary manslaughter. Before you can find that the defendant, Deshawn Stafford, guilty, you must find beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, the defendant, Deshawn Stafford, caused the death of Ethan David Liming as the proximate result of committing or attempting to commit aggravated assault. The state charges that the act of Deshawn Stafford caused the death of Ethan David Limey. Cause is an essential element of the offense of involuntary manslaughter. Cause is defined as an act that, in the natural and continuous sequence, directly produces the death and without which it would not have occurred. Defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences that follow in the ordinary course of events from the act. There may be one or more causes of an event. However, if the defendant's action or failure to act was one cause, then the existence of other causes is not a defense. The defendant is responsible for the natural consequences of the defendant's unlawful act, even though the death was also caused by the intervening act of another person. If the defendant inflicted an injury not likely to produce death, and if the sole and only cause of death was fatal injury inflicted by another person, the defendant who inflicted the original injury is not responsible for the death. Before you can find that the defendant, Deshawn Stafford, was committing or attempting to commit the underlying offense of aggravated assault, you must find beyond a reasonable doubt that the defendant, Deshawn Stafford, knowingly caused serious physical harm to Ethan David Limey. A person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably cause a certain result, or he is aware that his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that he was causing serious physical harm to Ethan David Limey. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge. When an act is a crime, a good motive or purpose is not a defense. Cause is an essential element of the offense of aggravated assault. Cause in this context is an act which directly produces serious physical harm to persons and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences that follow in the ordinary course of events from the act. There may be one or more causes of an event. However, if the defendant's act or failure to act was one cause, then the existence of other causes is not a defense. The defendant is responsible for the natural consequences of the defendant's unlawful act, even though the physical harm to persons was also caused by the intervening act of another person. Serious physical harm means any of the following: any physical harm that carries a substantial risk of death, or any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity, or any physical harm that involves some permanent disfigurement, or that involves some temporary serious disfigurement, or any physical harm that involves acute pain of such duration as to result in substantial suffering, or that involves any degree of prolonged or intractable pain. Substantial risk means a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur or that certain circumstances may exist. Under Ohio law, a person is allowed to use force in self-defense or in defense of another. There are two standards for self-defense and two standards for defense of another. Self-defense may be by deadly force. Self-defense may be by non-deadly force. Defense of another may be by deadly force, and defense of another may be by non-deadly force. The standards that apply to each of those are distinguished based on the amount of force used and the level of danger presented. Deadly force means any force that carries a substantial risk that it will proximately result in the death of any person. Non-deadly force means any force that does not carry with it a substantial risk that it will proximately result in the death of a person. Substantial risk has already been defined previously for you, and you will see as I read these that there are numerous definitions that you can refer back to. I will tell you when I have already defined the term that is used again. To determine which standard of self-defense or defense of another to apply in this case, you must first determine the disputed questions of fact. Once you determine the disputed questions of fact, you must apply the appropriate self-defense or defense of another standard based upon your findings. I'll first talk about self-defense and the use of deadly force. A person is allowed to use deadly force in self-defense. The state must prove beyond a reasonable doubt that the defendant, when using deadly force, did not act in self-defense. To prove that the defendant's use of deadly force was not in self-defense, the state must prove beyond a reasonable doubt at least one of the following. The defendant was at fault in creating the situation giving rise to the incident, or the defendant did not have reasonable grounds to believe that he was in immediate danger of death or great bodily harm, or the defendant did not have an honest belief, even if mistaken, that he was in immediate danger of death or great bodily harm, or that the defendant used unreasonable force. Caused, deadly force, and substantial risk have already been defined for you. The defendant did not act in self-defense if the state proved beyond a reasonable doubt that the defendant was at fault in creating the situation that resulted in the injury. The defendant was at fault if the defendant was the initial aggressor and Ethan Liming did not escalate the situation by being the first to use or attempt to use deadly force, or the defendant provoked Ethan Liming into using force, or the defendant did not withdraw from the situation, or the defendant withdrew from the situation but did not inform Ethan Liming of his withdrawal. In deciding whether the defendant had reasonable grounds to believe and an honest belief that he was in immediate danger of death or great bodily harm, you must put yourself in the position of the defendant with his characteristics, his knowledge or lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of Ethan Liming and decide whether his acts and words caused the defendant to reasonably and honestly believe that the defendant was about to be killed or receive great bodily harm. In determining whether the defendant, in using force in self-defense, reasonably believed that the force was necessary to prevent injury, loss, or risk to life or safety, you may not consider the possibility of retreat by the defendant. Words alone do not justify the use of force. Resort to deadly force is not justified by abusive language, verbal threats, or other words, no matter how provocative. A person is allowed to use force that is reasonably necessary under the circumstances to protect himself from an apparent danger. For you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant used more force than reasonably necessary and that the force used was greatly disproportionate to the apparent danger. In deciding whether the force used was greatly disproportionate to the apparent danger, you may consider whether the force used shows revenge or a criminal purpose. A person is also allowed to use deadly force in defense of another. The state must prove beyond a reasonable doubt that the defendant, when using deadly force, did not act in defense of another. To prove that the defendant's use of deadly force was not in defense of another, the state must prove beyond a reasonable doubt at least one of the following. The person being defended was at fault in creating the situation giving rise to the injury, or the defendant did not have reasonable grounds to believe that the person defended was in immediate danger of death or great bodily harm, or the defendant did not have an honest belief, even if mistaken, that the person defended was in immediate danger of death or great bodily harm, or the defendant used unreasonable force. Again, caused, deadly force, and substantial risk have already been defined for you. The defendant stands in the shoes of the person he defended. The defendant did not act in defense of another if the state proved beyond a reasonable doubt that the person defended was the one at fault in creating the situation resulting in the injury. The person defended was at fault if he was the initial aggressor, and the person defended did not escalate the situation by being the first to use or attempt to use deadly force, or the person defended provoked Ethan Liming into using force, or the person defended did not withdraw from the situation, or the person defended withdrew from the situation but did not inform Ethan Liming of his withdrawal. In deciding whether the defendant had reasonable grounds to believe and an honest belief that the person defended was in immediate danger of death or great bodily harm, you must put yourself in the position of the defendant with his characteristics, his knowledge or lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of Ethan Liming and decide whether his acts and words caused the defendant to reasonably and honestly believe that the person defended was about to be killed or receive great bodily harm. In determining whether the defendant, in using force in defense of another, reasonably believed that the force was necessary to prevent injury, loss, or risk to life or safety, you may not consider the possibility of retreat by the person defended. When considering deadly force in defense of another, you must apply the concepts of words and unreasonable force as I have previously set forth and defined. A person is also allowed to use non-deadly force in self-defense. The state must prove beyond a reasonable doubt that the defendant, when using non-deadly force, did not act in self-defense. To prove that the defendant's use of non-deadly force was not in self-defense, the state must prove beyond a reasonable doubt at least one of the following. The defendant was at fault in creating the situation giving rise to the incident. The defendant did not have reasonable grounds to believe that he was in immediate danger or danger of bodily harm, or the defendant did not have an honest belief, even if mistaken, that he was in immediate danger of bodily harm, or that the defendant used unreasonable force. Again, the concepts and the terms caused, non-deadly force, and substantial risk have already been defined. The defendant did not act in self-defense if the state proved beyond a reasonable doubt that the defendant was at fault in creating the situation that resulted in the injury. The defendant was at fault if the defendant was the initial aggressor and Ethan Liming did not escalate the situation by being the first to use or attempt to use non-deadly force, or provoked Ethan Liming into using force, or did not withdraw from the situation, or withdrew from the situation but did not inform Ethan Liming of his withdrawal. In deciding whether the defendant has reasonable grounds to believe and an honest belief that he was in immediate danger of bodily harm, you must put yourself in the position of the defendant with his characteristics, his knowledge or lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of Ethan Liming and decide whether his acts and words caused the defendant to reasonably and honestly believe that the defendant was about to receive bodily harm. In determining whether the defendant, in using force in self-defense, reasonably believed that the force was necessary to prevent injury, loss, or risk to life or safety, you may not consider the possibility of retreat by the defendant. When considering self-defense by non-deadly force, you must also apply the concepts, they're headed words and unreasonable force, words as they are related to self-defense, as I have previously defined. A person is allowed to use non-deadly force in defense of another. The state must prove beyond a reasonable doubt that the defendant, when using non-deadly force, did not act in defense of another. To prove that the defendant's use of non-deadly force was not in defense of another, the state must prove beyond a reasonable doubt at least one of the following. The person defended was at fault in creating the situation giving rise to the incident, or the defendant did not have reasonable grounds to believe that the person defended was in immediate danger of bodily harm, or the defendant did not have an honest belief, even if mistaken, that the person defended was in immediate danger of bodily harm, or the defendant used reasonable force. The defendant stands in the shoes of the person he defended. The defendant did not act in defense of another if the state proved beyond a reasonable doubt that the person defended was the one at fault in creating the incident that resulted in the injury. The person defended was at fault if he was the initial aggressor, and the person defended did not escalate the situation by being the first to use or attempt to use non-deadly force, or the person defended provoked Ethan Liming into using force, or the person defended did not withdraw from the situation, or the person defended withdrew from the situation but did not inform Ethan Liming of his withdrawal. In deciding whether the defendant had reasonable grounds to believe and an honest belief that the person defended was in immediate danger of bodily harm, you must put yourself in the position of the defendant with his characteristics, his knowledge or lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of Ethan Liming and decide whether his acts and words caused the defendant to reasonably and honestly believe that Ethan Liming was about to receive bodily harm. When considering self-defense by non-deadly force, you must also apply the concepts of words and unreasonable force as have been previously defined. If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter, or if you find that the state failed to prove beyond a reasonable doubt that the defendant, Deshawn Stafford, did not act in self-defense or in defense of another, you must find the defendant, Deshawn Stafford, not guilty of count 1, involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter, and you find that the state proved beyond a reasonable doubt that the defendant, Deshawn Stafford, did not act in self-defense or in defense of another, you must find the defendant, Deshawn Stafford, guilty of count 1, involuntary manslaughter. Now I'm going to move on to count 2. In count 2, the defendant, Deshawn Stafford, is charged with aggravated assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, the defendant, Deshawn Stafford, knowingly caused serious physical harm to Ethan David Liming. Knowingly caused and serious physical harm have already been defined. When considering count 2, aggravated assault, you must determine whether the state proved beyond a reasonable doubt that the defendant, Deshawn Stafford, did not act in self-defense or defense of another, and all of those terms have been previously defined related to self-defense. If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of aggravated assault, or if you find that the state failed to prove beyond a reasonable doubt that the defendant, Deshawn Stafford, did not act in self-defense or in defense of another, you must find the defendant, Deshawn Stafford, not guilty of count 2, aggravated assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of aggravated assault, and you find that the state proved beyond a reasonable doubt that the defendant, Deshawn Stafford, did not act in self-defense or in defense of another, you must find the defendant, Deshawn Stafford, guilty of count 2, aggravated assault. In count 3, defendant Deshawn Stafford is charged with involuntary manslaughter. Before you can find the defendant, Deshawn Stafford, guilty, you must find beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, defendant Deshawn Stafford caused the death of Ethan David Limey as the proximate result of committing or attempting to commit assault. Also in count 3, the defendant Tyler Stafford is charged with involuntary manslaughter. Before you can find the defendant Tyler Stafford guilty of involuntary manslaughter, you must find beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, the defendant Tyler Stafford caused the death of Ethan David Limey as the proximate result of committing or attempting to commit assault. And caused has already been defined. Before you can find the defendant Deshawn Stafford was committing or attempting to commit the underlying offense of assault, you must find beyond a reasonable doubt that the defendant Deshawn Stafford knowingly caused or attempted to cause physical harm to Ethan David Limey. Also, before you can find the defendant Tyler Stafford was committing or attempting to commit the underlying offense of assault, you must find beyond a reasonable doubt that the defendant Tyler Stafford knowingly caused or attempted to cause physical harm to Ethan David Limey. Again, those terms caused and knowingly have already been defined. Physical harm to persons means any injury, illness, or other physiological impairment, regardless of its gravity or its duration. As an alternative, the state has also presented the theory that the defendant, Tyler Stafford, acted in complicity with the principal offender, Deshawn Stafford, in the commission of the offense of involuntary manslaughter based upon the underlying offense of assault. A person who is complicit with another in the commission of a criminal offense is regarded as guilty as if he personally performed every act constituting the offense. This is true even if he did not personally perform every act constituting the offense or was not present when the offense was committed. Before you can find the defendant Tyler Stafford guilty of complicity in the commission of involuntary manslaughter, you must find beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, the defendant knowingly solicited another to commit the offense of involuntary manslaughter or aided and abetted another in committing the offense of involuntary manslaughter. Knowingly has been defined for you. A few more terms. Solicit. Solicit means to seek, to ask, to influence, to invite, to tempt, to lead on, or to bring pressure to bear. Procured means to get, obtain, induce, bring about, motivate, or motivate. Before you can find the defendant Tyler Stafford guilty of complicity by aiding and abetting, you must find beyond a reasonable doubt that the defendant Tyler Stafford supported, assisted, encouraged, cooperated with, advised, or incited the principal offender, Deshawn Stafford, in the commission of the offense, and that the defendant Tyler Stafford shared the criminal intent of the principal offender. Such intent may be inferred from the circumstances surrounding the offense, including but not limited to the presence, companionship, and conduct before and after the offense was committed. The mere presence of the defendant, Tyler Stafford, at the scene of the offense is not sufficient to prove in and of itself that the defendant was an aider and abettor. The principal offense of involuntary manslaughter based upon the underlying offense of assault has already been defined. The defendant, Tyler Stafford, cannot be found guilty unless the principal offense was actually committed. When considering this count 3 involuntary manslaughter, you must determine whether the state proved beyond a reasonable doubt that the defendant, Deshawn Stafford, did not act in self-defense or defense of another. Also, you must determine whether the state proved beyond a reasonable doubt that the defendant, Tyler Stafford, did not act in self-defense or defense of another when considering count 3 involuntary manslaughter. All of those terms relating to self-defense and deadly force and non-deadly force have already been defined for you. If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Deshawn Stafford, and if you find that the state failed to prove beyond a reasonable doubt that Deshawn Stafford acted in self-defense or in defense of another, you must find the defendant, Deshawn Stafford, not guilty of count 3 involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Deshawn Stafford, and you find that the state proved beyond a reasonable doubt that Deshawn Stafford acted in self-defense, you must find the defendant, Deshawn Stafford, guilty of count 3 involuntary manslaughter. Likewise, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Tyler Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Tyler Stafford acted in self-defense or in defense of another, you must find the defendant, Tyler Stafford, not guilty of count 3 involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Tyler Stafford, and you find that the state proved beyond a reasonable doubt that Tyler Stafford acted in self-defense, you must find the defendant, Tyler Stafford, guilty of count 3 involuntary manslaughter. Next, in count 4, the defendant, Deshawn Stafford, is charged with assault. Before you can find the defendant, Deshawn Stafford, guilty, you must find beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, the defendant, Deshawn Stafford, knowingly caused or attempted to cause physical harm to Ethan David Liming. Also in count 4, the defendant, Tyler Stafford, is charged with assault. Before you can find the defendant, Tyler Stafford, guilty of assault, you must find beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, the defendant, Tyler Stafford, knowingly caused or attempted to cause physical harm to Ethan David Liming. Those relevant terms, knowingly caused and physical harm, have already been defined for you. When considering count 4 assault, you must also determine whether the state proved beyond a reasonable doubt that the defendant, Deshawn Stafford, did not act in self-defense or in defense of another. Also, you must determine whether the state proved beyond a reasonable doubt that the defendant, Tyler Stafford, did not act in self-defense or defense of another when considering count 4 assault. All of those terms and concepts related to self-defense have already been defined for you. If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of assault as to Deshawn Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Deshawn Stafford acted in self-defense or in defense of another, you must find the defendant, Deshawn Stafford, not guilty of count 4 assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of assault as to Deshawn Stafford, and you find that the state proved beyond a reasonable doubt that Deshawn Stafford acted in self-defense, you must find the defendant guilty, Deshawn Stafford, guilty of count 4 assault. Likewise, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of assault as to Tyler Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Tyler Stafford acted in self-defense or in defense of another, you must find the defendant, Tyler Stafford, not guilty of count 4 assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of assault as to Tyler Stafford, and you find that the state proved beyond a reasonable doubt that Tyler Stafford acted in self-defense, you must find the defendant, Tyler Stafford, guilty of count 4 assault. Counsel, can you approach, please? All right, ladies and gentlemen, I'm going to go back to count 3 and reread to you kind of my conclusory paragraphs related to count 3. I did misspeak. There were a few incorrect words. They will be changed and corrected in the physical copy that you will receive, okay? But when we were talking about count 3, involuntary manslaughter, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Deshawn Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Deshawn Stafford acted in self-defense or in defense of another, you must find the defendant Deshawn Stafford not guilty of count 3, involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Deshawn Stafford, and you find that the state proved beyond a reasonable doubt that Deshawn Stafford did not act in self-defense, you must find the defendant Deshawn Stafford guilty of count 3, involuntary manslaughter. Likewise, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Tyler Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Tyler Stafford acted in self-defense or in defense of another, you must find the defendant Tyler Stafford not guilty of count 3, involuntary manslaughter. If you find that the state proved beyond a reasonable doubt all of the essential elements of involuntary manslaughter as to Tyler Stafford, and you find that the state proved beyond a reasonable doubt that Tyler Stafford did not act in self-defense, you must find the defendant Tyler Stafford guilty of count 3, involuntary manslaughter. And then we discussed the beginnings of the count 4 assault, which requires that the state prove beyond a reasonable doubt that on or about the 2nd day of June 2022 and in Summit County, Ohio, the defendant Deshawn Stafford in the first instance, and the defendant Tyler Stafford in the second, knowingly caused or attempted to cause physical harm to Ethan David Liming. Self-defense, we talked about, does also potentially apply to this count, and you must consider those concepts and definitions as they have already been given to you as to count 4 assault. If you find that the state failed to prove beyond a reasonable doubt all of the essential elements of assault as to Deshawn Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Deshawn Stafford acted in self-defense or in defense of another, you must find the defendant Deshawn Stafford not guilty of count 4 assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of assault as to Deshawn Stafford, and you find that the state proved beyond a reasonable doubt that Deshawn Stafford did not act in self-defense, you must find the defendant Deshawn Stafford guilty of count 4 assault. Likewise, if you find that the state failed to prove beyond a reasonable doubt all of the essential elements of assault as to Tyler Stafford, or if you find that the state failed to prove beyond a reasonable doubt that Tyler Stafford acted in self-defense or in defense of another, you must find the defendant Tyler Stafford not guilty of count 4 assault. If you find that the state proved beyond a reasonable doubt all of the essential elements of assault as to Tyler Stafford, and you find that the state proved beyond a reasonable doubt that Tyler Stafford did not act in self-defense, you must find the defendant Tyler Stafford guilty as to count 4 assault. Testimony has also been admitted indicating that the defendants fled the scene. You are instructed that defendants' actions in fleeing alone do not raise a presumption of guilt, but it may tend to indicate the defendant's consciousness of guilt. If you find that the facts do not support that the defendants fled the scene, or if you find that some other motive prompted the defendant's conduct, or if you are unable to decide what the defendant's motivation was, then you should not consider this evidence for any purpose. However, if you find that the facts support that the defendants engaged in such conduct, and if you decide that the defendant was motivated by a consciousness of guilt, you may, but are not required, to consider that evidence in deciding whether the defendant is guilty of the crimes charged. You alone will determine what weight, if any, to give to this evidence. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdicts as to any other count. The defendants may be found guilty or not guilty of any one or all of the offenses charged. You must also separately decide the question of guilty or not guilty relative to each of the two defendants. If you cannot agree upon a verdict as to both the defendants, but do agree as to one, you must render a verdict as to the one upon whose guilt or innocence you do agree. You must separately consider the evidence applicable to each defendant as though he were being separately tried, and you must state your findings as to each defendant uninfluenced by your verdict as to the other defendant. Counsel, are there any other additions or corrections to the jury instructions so far?
I would renew my objection.
That objection will be renewed. And then at this time, ladies and gentlemen, as we discussed, I will take a somewhat shorter lunch break. Why don't we reconvene? Okay. So let's take about a 45-minute break for lunch. Let's reconvene about 1 o'clock. At that time, we will continue with the closing arguments of counsel, and then I will finish the instructions related to how you should conduct your deliberations. We still have, obviously, some things to present in these proceedings. You are not to begin discussing amongst yourselves the case at all until we have finally concluded. And once again, do not discuss the matter with anyone else. And I will see you after lunch.
All right.
stronger than a regular pill, right? No. Okay. Spinal headache. What's that? She doesn't really limit us. I mean, Matt's probably got a good 40 minutes or so, and I don't know about anybody else. So, but yeah.
Just a reminder, no cell phones, advised on the ballot. Thank you.
Okay, can all three of these together? All three of these files, we have the jury. These three, each of them together for all three of these files.
Okay, please be seated. Ladies and gentlemen, at this time, counsel is prepared to present their closing arguments. As we have discussed in the past, closing arguments are not evidence, but they are counsel's opportunity now to review for you what they believe the evidence has shown over the last few days. So on behalf of the state, Mr. Kuhn.
Thank you very much, Your Honor. Judge, may I please report? Good afternoon, opposing counsel. Good afternoon, ladies and gentlemen of the jury. As I introduced myself previously, my name is Matt Kuhn. I'm one of the assistant prosecutors here for Sumter County. I'll be doing the first portion of our closing argument today. It'll be split up into two parts. I get a chance to try to direct your attention to some of the evidence that we've seen and heard throughout the last week. And then the defense gets a chance to submit for your consideration what they think are important pieces of evidence or things to focus on. And then my coworker, Prosecutor Shook, will get a chance to do a rebuttal. And so I know you folks have done a great job thus far paying attention, and we all listened to the judge's instructions regarding the law, and those were kind of tedious. It took a long time to read through that. It's not an easy process. When you folks agreed at voir dire to become part of this jury, you knew that this was your civic duty. Okay? It's not called civic fun time. It's a duty. It's a very solemn event. And in certain cases that are maybe less serious, we'll say, of less magnitude, there might be a little bit of joking around throughout the trial process. And there were maybe a couple lighter moments throughout the trial here. I think there was a comment about the Browns game Monday night, and a few folks sort of chuckled or something. But in a case like this, it's very difficult to joke around much. And part of that reason is because I want to appear as a serious person, a serious professional. And I believe I am. But part of it is that I do not want to insult any of the spectators on either side here, because this is a very serious process that we're engaged in here. This is very serious. It's not a joke for these two young men right here. It's not a joke for us. I'm sure it's not a joke for you. It's not a joke for these folks. And part of it is it's not a joke for Ethan. Okay? And I'm going to put my PowerPoint up here on the screen in a minute. And so I probably will just be sort of holding up some of the state's exhibits that we've used throughout the course of the trial. I won't be putting them up on the screen, but you'll have all these things back in the back. Okay? And I want you to take your time, and I'm sure you will, and go through them and give them that same due respect that they deserve. You folks have heard these names, heard this case number. State of Ohio versus Deshawn and Tyler Stafford. You know that's what we've been hearing all week. And by now, I hope it's been made clear to you, we are talking about an event that was on June 2nd of last year. So last summer, a little bit over a year ago. And that was at about 10:45 at night, maybe a little bit before that. Over at the I Promise School, 400 West Market, obviously here, Akron, Summit County, Ohio. Those are things that we had to prove. We couldn't just say, oh, this was at I Promise, and sort of hope or assume that everybody knows what that means. Proving where it occurred is part of the process, and so that's why we would oftentimes ask witnesses where it is. Oh, hey, is Akron in Summit County? Obviously it is, but we have to prove that so that can be demonstrated on the record. Okay? And we got witness testimony. I think undisputed testimony that the Stafford brothers and their cousin Donovan were hanging out at the school, minding their own business. That's the tough part of this case. These guys were minding their own business and were sort of involved in a prank that Ethan and his friends decided to pull. They approached the school in a car at night in the dark, rolled up on it quick, hopped out, ran up shooting these splatterball guns. Not a bright idea. However, most pranks are not bright ideas. It was a joke. It was a goof. They shot the splatterball guns, and presumably it had the desired effect that the folks on the basketball court ran to the far end of it. They believed something was going on that they did not want to be a part of. Whatever it was, didn't have the marks of something good. They ran. At some point, however, it became clear to them. And we got testimony and reports that Tyler yelled out, "It's a fake gun. It's a toy. It's a prank. It's a joke." Okay? Perhaps rightly so. The young men on the basketball court were not happy campers about that. Okay? And we saw the video. You'll have that back there for your consideration as well. You will have all the videos that we've watched. If we went through them too quickly, or if there was a part you didn't quite catch what happened, you can watch it to your heart's content until you are satisfied that you've reviewed that evidence to your satisfaction. But the video shows that Ephraim and Mekhi hop out. Ephraim hops out the front driver. Mackay's in the back seat, or no, Ephraim's front passenger, Mackay's back passenger seat. They run up, shoot the splatterball guns. We got to hear that. It was a fairly loud, annoying sound. We are in a room with enclosed walls and ceiling. I would submit to you that it may sound differently outdoors in the wide open. Additionally, I would submit to you, and we have testimony, it doesn't sound like a gun. It might sound like something annoying or weird. It does not sound like a gun. It does not sound like a machine gun. Okay, when Ephraim and Mackay run back to the car, I think everybody's pleased that the prank has gone as expected. They caused the guys on the court to run, and that's how a prank goes. However, the gentlemen on the basketball court were not as pleased about it, and we see video of Deshawn approaching the car. And he's walking from the court, he has a basketball, and at a certain point, the basketball goes to the ground. I would submit to you that that's in the video. It may not have been clear when we're watching it on the screen here, but I would submit to you that you can see that happen as Deshawn walks past the passenger side of the car. He drops the ball and walks around the back side of the car to approach the driver, Ethan, who has now stepped out of the driver's seat of the car. I would submit to you that the purpose for dropping the basketball is because he is no longer playing basketball. Something else is about to happen. When Deshawn approaches Ethan, according to the testimony of the witnesses, and according to Deshawn's statement, Ethan shoots Deshawn with the splatterball gun. We had testimony that it was in the upper torso. We had some testimony that it was possibly in the face. Again, not a great idea. However, we also had testimony that at that point, the kids in the car still believe that this is a funny prank, and they testified that they saw Deshawn's face, and he did not seem upset. He was grinning or smirking or laughing. And we heard testimony that he said, are you serious? Is this serious? Something to that effect. If I recall correctly, that was Lamarion who supplied that information. And it was not clear that Deshawn was upset until Deshawn went for the gun, went for the splatterball gun. Understandable. At that point, the testimony that we heard was that Deshawn punches Ethan and the fight is on. Okay? And the reason why I just did air quotes right there is because perhaps initially, maybe right at the very start, maybe that is a fight, a mano type of a deal. Ethan versus Deshawn. Now, we heard a lot of chatter early on, perhaps in opening statements from the defense about the hulking giant that was Ethan. And we heard testimony that he was a good-sized young man, good-sized kid, but he's not the Incredible Hulk. He's 5'9", 172 pounds. That was verified by the medical examiner who personally measured his dead body and weighed his dead body with a scale that is calibrated on a yearly basis. There was this physical altercation. It didn't last long as a one-on-one fight. Almost immediately, Tyler and eventually Donovan join in. We heard that it went from one-on-one quickly to 2-on-1 and 3-on-1. Those are bad numbers. Those are bad numbers to be in a fight. And we heard testimony, and it's corroborated by not only the videos that we have, but also the physical evidence and the photographs that we have, that this fight, this assault, it sort of progresses down the parking lot. And we were all out there the other day. We had the good fortune of being able to go out there in daylight hours, and they had it blocked off for us so that we were not interrupted or had a bunch of cars in the parking lot blocking our view or maybe inhibiting our understanding of where everything was. We had a great opportunity to walk around that parking lot and the basketball courts ourselves and see for ourselves the lay of the land. Okay? And the reason why I bring that up is because much ado was also made about the terrible potholes, the pothole defense, okay? or the sloped land defense. Okay? We were out there, we walked around on it. There's a gentle slope, a very gradual slope, perhaps the minimum to allow rainwater to seep towards a common area. It's a parking lot. Parking lots are inherently flat. But we heard the testimony that in that moment, when Ethan is outnumbered, okay, and by now he's away from his car. Imagine being in a fist fight and separating yourself from your mode of transportation. He's now over by the light pole, and we heard the reports of him getting knocked out. Mackay said he was able to see it. But more importantly, I would suggest for your consideration, he was able to hear it. He heard the knockout blow. And the defense did some follow-up questions with him on that issue. Well, probably what you mean is you saw him get punched, and then when he hit the ground, you probably heard that sound. No. That's not what it was. He heard the punch. He said that. All three of the young men, the boys that were with Ethan, saw it from start to finish. Ethan went down one time when he was knocked out. There was no fight where he's in it and he's holding his own and then he gets knocked down, then he gets up or he's led up. That never happened. He went down one time. And another thing I wanted to clarify is the use. I've said boys and young men and that sort of thing. And there was much chatter about these guys here being called boys. In voir dire early on, the defense referred to them as boys. There was some confusion about their age as people were testifying. These are young men. They are adult men. The kids in this story, the boys in this story, were in Ethan's car. Just for clarification, to call a grown man a boy is either insulting or disingenuous or both. These are young men. We saw that Ethan was dead at the scene there. We saw that he was knocked out, never to move or make a sound again, other than maybe some minor noise associated with coughing up blood. He never moved on his own again. He was slightly moved after the fact by his friends who were trying to load him into his own car. Loading him into the back seat of his own car And we see in some of the photographs the blood trail. The bloody trail on the ground from where Lamarion first got to him and tried his best to move him to a more convenient spot on the card to get him in. And he and Mackay were unable to do so. They provided a couple different explanations for why they were unsuccessful. One was that they were trying to move a dead body. And we saw Mackay, we saw Lamarion. I would suggest that they're nice, now young men. And they both appear somewhat muscular, fit. This was a year ago. They were unable to come together and move their friend's dead body. That wasn't simply because of the weight. It was because their efforts were being inhibited by three people: Donovan and the Stafford brothers. And we saw much testimony, we saw in the video how that was going on. I ask you to take another look at it. We know Donovan was reaching in the driver's door of Ethan's car, but Mackay's in the driver's seat because he was summoned to bring Ethan's vehicle to try to load up his body. And Ephraim is in the passenger seat trying to make a 911 call. The reason why Mackay was summoned, hey, bring Ethan's car down here, is because they knew it was bad. It was bad news right from the rip. Nothing good was going to happen next. They knew it was an emergency. They knew that this was a life and death situation. You don't call 911 just in case. Those are last resort type of behaviors. The other thing that's a last resort behavior is running home, possibly a mile, and hiding behind trees as you go because you are scared to death. I would submit for your consideration that not only is it significant that Ethan, was forced away from his vehicle, not only his mode of transportation, but maybe the thing in the world that's the most valuable to him. Some people are attached to their cars. Okay, some people are also attached to things like their wallet or their identification card or their cell phone. Okay? And when Ephraim and Mackay and Lamarion ran away from the scene, when they left the scene, they left their phones back at the scene. I submit for your consideration, that's a significant point to focus on. The very dire circumstances that they believed they were in. Okay. The judge has instructed you about the different charges. And you'll have that big stack of papers that the judge was reading from. And when you sit in those chairs, it might start to all sound the same to you. And it's maybe tough to fully absorb it and appreciate what the things mean. So when you get back there, you'll have to take a look. And I'm sure you will do so. But these are the different charges that Deshawn is charged with. Involuntary manslaughter, aggravated assault, another count of involuntary manslaughter, and a misdemeanor assault. Okay? And in the state of Ohio, the judge is going to give you these laws, but if you commit assault or aggravated assault and it causes the death of a person, that is called involuntary manslaughter. Okay, so there's one count related to the aggravated assault, and there's another related to the misdemeanor assault count. Okay, Tyler he has involuntary manslaughter simply relating to that misdemeanor assault that we talked about, and also the misdemeanor assault. And I put up there that Deshawn also has those charges. So they each have 2 counts that are the same, but then Deshawn has his own 2 counts. Because the evidence showed that he threw that knockout blow that caused Ethan to fall, never to recover from, never to stand up from. Before I move on, again, you'll have all these things, but I was talking about the boys leaving their phones. I mean, you have these images here. There's Lamarion's identification card and his shattered cell phone. They testified that their phones weren't shattered when they had them. It was only afterwards. And we see that in the video. We see when Tyler moves the car, he hops out and he throws one of them down and it's shattered. You'll have that evidence photo to look at. Additionally, a couple things to call your attention to. I've touched on the fact that Ethan was separated from his vehicle. That at some point he was compelled away from, again, his mode of transportation, his possession, and his buddies. That's a bad combo when you're in a fight and you're outnumbered. Okay? To add to it, he didn't have on shoes when the cops got there. Okay? And we have photographs of his sandals strewn about. Okay? One's up closer to the car, one's a little bit further down near his body. Basically, they came off in the course of this. It's not from stepping on a pothole. It's not because it was such a steep hill. It's because he was getting attacked and he was outnumbered. Okay. And relative to the pothole defense, we have photographs. There'll be an evidence here for you to look at. You were out there. Maybe that lot's been repaved since then in the last year and a couple months. I don't know. It's not in evidence. Nobody testified that it's been repaved. Maybe. Okay? But we do have photographs to show the condition of it. And I'd suggest to you that it's in relatively the same condition. There are filled potholes. There are not gaping potholes. This is the night of the incident. This is the night of the attack. There's no gaping potholes in the ground there. We do have Ethan's shoes. That's a pretty flat chunk of land right there. Okay. Additionally, I talked about leaving behind your possessions. Okay. And in placard number 4, we had testimony that this is Ethan's wallet right here, next to the splatterball magazine that would hold the Orby gel balls. This is his wallet at placard number 4. And if we look at the photo of the overall scene, we see that placard number 4, so that's the wallet and the Orbeez magazine, are over here. So going from his car, if he wanted to put those items there, he would have had to walk past the spot where his body lays, set them down, and then walk back over here where he would ultimately be found dead. In breaking down the charges for these 2 young men, I'm going to start with this, essentially the least serious. That's assault. Okay. Knowingly causing or attempting to cause physical harm to another. That's the definition, approximately, of assault in the state of Ohio. Deshawn and Tyler are both charged with that. Knowingly causing or attempting to cause physical harm to another, in this case, obviously, Ethan Minor. And they're both guilty of it. This wasn't an accident. They did cause or attempt to cause him injury by punching his face, hitting his face. The physical harm. We saw the photographs. We saw the brutal photographs from the scene, from the night of the incident. We saw the other brutal photographs in the autopsy PowerPoint. We saw the injuries to his lips, both lips, and a bloody nose. Look at his lip. I asked the ME on purpose, hey, maybe that's just dried blood on his bottom lip there. Maybe it's not as bad as it seems. He said, oh, no. Those are injuries. That is not dried blood. His mouth has been cleaned up. Those are cuts on the inside of his lip from being blasted back into his teeth so hard that it cut the inside of his mouth. His upper lip was a purple, puffy mess. We also saw the blood still in his nose. The doctor couldn't tell us exactly how far up that bloody nose began. He said, it could be from one punch. Please use your common sense and think about whether those injuries seem like one punch to you. They do not. Likewise, I asked about the injuries to Ethan's eyebrow and forehead. And I hope it doesn't come across as though I'm yelling at you. That is not my desire. I'm hoping that you're gathering that I am passionate about this issue, and a lot rides on it, and so I want to make sure that I'm hitting all the points I want to. So please, if I'm getting animated, I apologize. But everyone knew that Ethan was knocked out on the spot. Ephraim knew it, Mackay knew it, Lamarion knew it, these guys knew it, Donovan knew it. He was down for the count. There were some questions from the defense about a woozy boxer getting up after 20 seconds or something. It didn't happen here. He was down and it was over. He was dead. Everyone knew it. He never made another audible noise other than a sound related to coughing up blood and no movement. We have Deshawn's statement that he continued to hit him. I don't think he said whether it was a punch or something else. He continued to hit him. Okay? And Deshawn also explained that he got some injuries in this fight as well. Okay? And Deshawn told us through the interview that it was a fight. Okay? And something to the effect of either that he was fighting them or that we were fighting them. Somehow it was like maybe fair numbers or something. Okay? And there were maybe 4 guys total on Ethan's team. Okay? And maybe initially one would think, okay, there's 3 of us and there's 4 of them. I guess that's close. But it became very evident very quickly the other boys were not jumping in. They were scared. They bit off more than they could chew when they engaged these strangers at the basketball court. They were not expecting probably any response. And when they got a response, they were not prepared for it. We got reports that both brothers assaulted Ethan. Everybody did. Donovan did as well. 3-on-1. Everybody was hitting him. Okay? Now moving on to the next serious charge. Aggravated assault. Okay? So this is a lot like the assault one we just covered, except now we get into serious physical harm. Okay? And only Deshawn has this aggravated assault count. And that's because he threw the knockout blow. Okay? He was offended that maybe he viewed it as being the butt of a joke or something, the butt of the prank. Okay? And he was upset about that. And it appears on the video that they all run, that they sincerely believe something not good is going on. However, we know that he finds out that it's fake. Either he gathers that on his own after some time goes by and there has been no sound of a real gun. There has been no bullets hitting anything. Or at the absolute latest, when Tyler yells out, "Hey, it's fake. This kid's messing with us. It's fake." Okay. And so there may have initially been some provocation by Ethan's group, by Ephraim and Mackay running up there and doing their little prank. Okay, and Ethan's part of that. He drove them there. It's his splatterball gun. He's a part of that provocation. And then, when Deshawn approaches Ethan, he apparently continues to shoot Deshawn. Probably upset. That'd be annoying. However, what came next was just so dramatically over the top. It's just not even a close call that it's over the top and not appropriate. Everyone was able to see that Ethan was unconscious and that he had gotten knocked out and blindsided. And Deshawn continued the assault. He continued to hit him. Okay? And so serious physical harm has a few different definitions. The judge read them to you, and you'll have them. But one of them has to do with physical harm with substantial risk of death. And during voir dire, the defense asked the jury, prospective jurors, about the notion of whether a punch is dangerous, if it's deadly or not, something to that effect. And one of the jurors who was not with us, I believe, explained about seeing a person get knocked out with one punch, getting hit on the side of the head, side of the forehead, and that could actually be very dangerous or deadly. Okay, so people know that. It's understood, okay, that there is a risk of death there. Okay? And the attorney even tried to maybe negotiate with the prospective juror about it. Maybe he didn't understand correctly. He stuck to his guns. He's like, no. I believe he said he was going to fight in the 70s or something, and saw it happen. But additionally, another form of serious physical harm is harm that involves some permanent incapacity. Okay? And here we have total incapacity where Ethan is knocked out. He is unconscious. Okay? And then it's like, well, okay, is that a temporary thing or is it a permanent thing? Okay? And for Ethan, it turned into a permanent thing. He was permanently, totally incapacitated. So, but my point there for you to consider is that even if these guys don't know initially that he's dead, that he's just knocked out, that's good enough for that definition right there. That would be a temporary total incapacity, being knocked out or being in a coma. Okay. And then also temporary serious disfigurement. We saw the injuries, the bloody injuries to Ethan's face and to his side. The mark on his side. That's disfigurement. Involuntary manslaughter for both Deshawn and Tyler. Okay? No person shall cause the death of another as a result of the offender committing or attempting to commit any misdemeanor. In this case, misdemeanor 1 assault. And the judge will supply the elements for you to consider. But their behavior caused the death of Ethan Lyman. Okay? They were committing assaults on Ethan. They were violently attacking him. It was not a fight. Fight's not the right word. They were attacking him. They were assaulting him. Okay? And the judge read an instruction related to complicity. Okay? And the testimony has shown that Deshawn threw that knockout blow. He might have done it like this. He might be right-handed. And it blindsided Ethan. And that was the knockout blow. That was the assault that then caused his death. However, Tyler was involved in that fight. Whether it was 2-on-1, 3-on-1, doesn't matter. They were both involved in it. They were aiding and abetting each other in this physical altercation. They were both in it together to fight Ethan. Okay? Or we heard testimony, and it was in Deshawn's statement that his brother called him. Deshawn, that's calling out for help in the fight. Hey, let's get him. Now, those were not the words used, but that was the meaning of it. Okay, as I indicated, all of the testimony from Mackay, Ephraim, Lamarion, all of it was consistent that there was the knockout blow, but that everyone was hitting Ethan. Everyone was. Okay. And we saw the injuries. Those could not be the result of a lucky punch or unlucky punch or two unlucky punches. It's more than that. Involuntary manslaughter. No person shall cause the death of another as a result of committing a felony, in this case, aggravated assault. We already talked about aggravated assault as causing serious physical harm. Okay, if the person dies, boom, you have this charge now too. Caused death during the aggravated assault. The death was the natural and continuous consequence. It was the next thing in the sequence of events without which the death would not have occurred. We know that from Deshawn's own statements, that when he hit Ethan, Ethan went right to sleep. And we listened to that recorded interview. The audio was not perfect. However, you'll have it with you back in the jury room. Listen to it 100 times if you need to. It's in there. He said he went right to sleep. We also know that from Tyler's statement that that's what happened. And we know that the death was caused that way from statements from the medical examiner. He went into great detail about how once a person is unable to control their movements, once they are incapable of doing so, they are extremely vulnerable when falling. They cannot protect themselves or do movements to guard themselves. They're in an extremely fragile position at that point. Ethan was in that point when he fell, and when he continued to get ground and pound on the ground afterwards. We probably learned what ground and pound means. Lamarion used that phrase, and he explained what it meant. That after Ethan was on the ground, no movement, no sound, that the person attacking him continued to hit him. That is consistent with the statement that Deshawn made. He said he did that. It is not suggested here that anyone set out to kill somebody that day. As I indicated, it's a very tragic situation. I told you these guys were minding their own business. Okay, but that only gets you so far. You cannot exploit some situation that you suddenly find yourself in. You can't capitalize on that or just go crazy and use that as some vehicle for you to commit a crime. Unfortunately, the law does not allow that. And the reason why that's important, and I would suggest to you the reason why I'm pointing that out is because the judge has instructed you and will instruct you not to think about things like sentencing or sympathy. That's not your job. Your job is simply to determine the facts of what happened that day. And if you start getting into things related to sympathy, whether it's that maybe they initially were minding their own business or something, you're not doing your job. You took a very solemn oath to be a juror and apply the law to the facts. That's your only job. You are not allowed, you are not permitted to sort of disregard or turn a blind eye towards the law as the judge gives it to you and replace it with your own gut feeling or some notion of vigilante justice or street justice, something like that. You're not allowed to do that. You can only use the law that the judge gives you. This is a very bad situation. Terrible. That doesn't do it justice. Okay? But you don't get to say, well, yeah, they did it, but it was a bad situation, so we better not hold them accountable. You are not permitted to factor that in there. Okay. Punching and hitting a person is not accidental, whether that person's unconscious or not. I would suggest to you that punching a person who's unconscious is perhaps more egregious. Okay. It caused serious physical harm. It caused Ethan's death. And we went through some very lengthy jury instructions there about self-defense. Self-defense is, I did it, but I did have a legal justification, and so it was all justified. In the state of Ohio, in order for the state to overcome a claim of self-defense, the state must prove at least one of the following. Could be more, but we just have to prove one of them. That's the threshold. Okay? And so the state has to prove, it has proven that one of these four, that the defendant was at fault in creating the situation, giving rise to the affray. The evidence showed that Deshawn approached Ethan and engaged him. And then shortly thereafter, Tyler and Donovan did the same. The evidence also showed that Deshawn threw the first punch. That is the uncontroverted evidence. There was no other testimony to contradict that. The first punch was thrown by Deshawn. Done. Lamarion said it. He was certain of it. I would submit to you that you could very easily find that the defendants were at fault in this situation. Okay. Next, the defendant did not have reasonable grounds to believe that he was in immediate or imminent danger of death or great bodily harm. Nobody at the basketball court was in danger of death or great bodily harm. If they had any concerns about that initially, those were gone by the time Deshawn came over to the car. It was clear that it was a prank, that it was a joke. Ethan posed no physical threat to anybody there that day. He had his splatterball gun. He was not interested in a fist fight. He was not dressed appropriately for a fist fight. Okay, and then the defendant did not have an honest belief, even if mistaken, that he was in imminent or immediate danger of death or great bodily harm. Same kind of an idea here. Okay, and I'm going to touch on that in a couple slides here. But also the last one, and I would suggest is, for your consideration, is probably the most significant one, is the unreasonable force. Please really give that one some consideration when thinking about the evidence that we've seen and heard here this week. Okay, and there is another one about duty to retreat that does not apply to this situation. Okay, the defendant had fault in creating the situation. Deshawn immediately, I called it up the ante. He immediately turned this thing from a stupid prank into a fist fight. Okay. And Tyler immediately jumped in to help his brother. Okay. A couple things. It did not need to be a fist fight. That was not necessary. Okay. It definitely didn't need to be a 2-on-1 fist fight. And it really didn't need to be a 3-on-1 fight. And I mentioned calling it a fight is insulting. That's not the right word for it. A fight insinuates that there was some sort of contest. Okay. The next prong of this test here, it was not reasonable grounds to believe immediate danger of death or great bodily harm. Okay. Neither of the Stafford brothers were in danger of death or great bodily harm. Ethan was outnumbered, with no shoes on. He was separated from his buddies. He was a sitting duck. It was a 2-on-1 fight and a 3-on-1 fight. Okay? Some people might call it an assault with a toy gun. That's what he called it. He called it that. It was basically an assault with a toy gun. And that was one of the spots in the interview that it was sort of quiet. You sort of had to focus to hear him say it, but he says it. And I asked Detective Hornacek about that to follow up on it, just in case you all didn't catch it. Listen to that interview again if you need to. I believe it's at the 1 hour, 34-minute mark, as I said up there. It's on there. He said basically it was an assault with a toy gun. He didn't say it was an assault with fists. He didn't say, yeah, it was a fist fight. It was mutual combat. You know, I told him I was going to beat him up. He told me he was going to beat me up, and we tried. Nope. Assault with a toy gun. No one at any point has given any indication that Ethan's buddies jumped in or attempted to jump in. It's a sad fact of this case. When we envision ourselves doing things and how we would react in a certain situation, you might envision that you would be a hero and you would charge right in and get your buddies back and you would do what you could to help them out. But unfortunately, for everyone, for mankind, a lot of people freeze up. They don't know what to do. Okay. And another reaction that some folks have is flight. Okay, we ultimately saw that as well. So initially we see the three boys, Micah, Ephraim, and Lamarion, essentially freeze. They're like, uh-oh, this ain't good. Lamarion runs over. By all accounts, he gets the closest. he goes to where Ethan is on the ground. And he told us that he would end up touching him. But before we get to that part, he said he touched the back of one of the brothers. Okay? And he didn't know exactly which one, but it was the one doing the ground and pound. It was Deshawn. He touched him, and he said Deshawn flinched at him. And so Lamarion felt he had no choice but to back off. Ephraim stuck by the car. He didn't know what to do. He was armed with a splatterball gun. Okay? And a number of times throughout the trial, we heard questions referring to it as a weapon. It's not a weapon like you might think. If you think it's a weapon like a gun, you are sadly mistaken. That is a toy. Now, it is an object, so I suppose almost any tangible object could theoretically be a weapon. And we did hear testimony about it being used as a weapon by smashing it on Ephraim. There was no indication it was used as a weapon by shooting by either the Stafford brothers or by Donovan. The only way it was used as a weapon was by getting it smashed on Ephraim, and we see the broken pieces of it at the scene there. And I mentioned that I would suggest that Donovan and the Stafford brothers, not only did they overreact, but and they went way too far, but they were capitalizing on the situation and retaliating. Okay? It extended something beyond whatever vague or sort of initial sense of justification or self-defense. It went beyond that into retaliation. And that is the word that Lamarion used. There was some questioning about it being self-defense, and Lamarion chuckled and referred to it as retaliation. This wasn't, oh, I'm scared, oh my heavens, This was ground and pound. Speaking of retaliation, before we move on, we already touched on the wallet being separated from Ethan. We didn't hear any testimony about how it got separated from him, but it is separated from him. And his pockets were curiously turned inside out.
Objection.
Okay, proceed, Judge.
You may.
Great, thank you. In looking at the evidence in what I call the debris field there in the parking lot, the different placards and markers and things, we also see where Ethan's vehicle ends up after all this is over. And it's not dramatically far from where it started. pretty close in proximity. However, in between there, it was driven by Mackay down to the light pole, and then it was there briefly, and then when Ephraim and Mackay and Lamarion ran away, Tyler hopped in and drove it back around. I believe Detective Hornacek called it near the mouth of the parking lot, or the entrance to the I Promise School. And much ado was made about the sunglass holder, the door for the sunglass compartment being ripped out of the car and being thrown in the parking lot. There's no self-defense that relates to that, folks. We talked about how it became very apparent very quickly to everyone on the court that the prank was just that. It was a toy gun. At the absolute latest, Tyler yelled and made it known to everyone. Okay. And then we talked about unreasonable force. Okay, you can use force necessary to protect yourself. Okay. That's a-okay. Okay. And one could maybe buy into the notion that a punch would be necessary to stop someone who is continuing to shoot you in the upper torso or even the face with a toy gun. Rely on your collective life experience about what force would be necessary to stop someone from shooting you with a toy gun. In this case, the reaction, talk about the retaliation, was greatly disproportionate to whatever apparent danger that Ethan immediately posed or that he initially posed. Okay? And the court will give you an instruction about the force, the amount of force. And you can contemplate, you'll be able to think about whether all this behavior, everything we saw, the whole sequence of events, if maybe it shows revenge or a criminal purpose. Okay, like retaliation. Okay. And we heard from Lamar, it's retaliation. We heard about the ground and pound on an unconscious person. Okay. What injuries did the Stafford brothers have? We don't have any report of any injuries to Tyler. Nothing. Not a thing. Deshawn does say he was injured. Okay, and he told the police his version of events. Okay, and he explained his injuries. And if you watch the video, he sort of, motions to his arm and suggests that the scab on his arm is related to an injury. Okay, Ethan, maybe Ethan did some. No, Deshawn explains. No, that was from when I slammed it. Hurt my arm, and I also hit my head. So his injuries from the fight were from when he slammed the kid. Okay. But he had some more injuries. He had injuries to his other hand, to his right hand. And he explained that those were from hitting Ethan. Those were his injuries. The ones he got when he slammed Ethan on the pavement, and the ones he got from punching Ethan. Think about if those are in any world proportionate to the injuries that we saw. He mentioned his knuckle might have been broken. That seemed to be at the question posed by the detective. He said he thought it was, but he didn't get any medical attention. Now, mind you, that's 9 days later, after Deshawn was picked up by the fugitive task force. we heard about the splat ball gun that was collected from 515 North Howard, and that was Deshawn's, that was where he stayed, that's where the gun was, that he collected as evidence, like a junior detective or something. He collected evidence by his account. He collected it, but then he didn't do anything with it. It was only collected 9 days later at the insistence of APD. Okay, there's an instruction in there about the defense of others. It's very similar to self-defense. The same notions apply. The same arguments apply. I don't want to go crazy here and go through everything again in the same amount of detail. But the same kind of a thing. You have to have reasonable grounds to believe that the person was in immediate danger. Okay, or it has to be an honest belief. It can't be phony baloney. That's why that rule's in there, is because sometimes people will capitalize on the self-defense law and say, oh, it was self-defense. And this rule, it cuts out anyone who is fibbing about that. Anyone who just simply capitalized on an opportunity to beat up a dude when he's knocked out. Or beat up a dude who is outnumbered. That's to cut out the phony claims of self-defense or defense of another. Like, oh sweet, my buddy's in a fight over, I can just run in and I can join in too, and I can just say, oh, it was defense of another. That cuts that out. Okay, and there's also the unreasonable force prong there as well. We talked about why that fails. 2-on-1 fight, not reasonable. 3-on-1 fight, definitely not reasonable. Okay, in terms of the defendant being in fault, the initial aggressor, Ethan did not escalate it by using deadly force. He didn't do it. Okay? The defendant provoked Ethan into using whatever amount of force he was able to put up before he was knocked out and done for. Whatever amount of force, if he was able to get any punches in, whatever, that was provoked by Deshawn throwing that first punch. Okay, you do have a duty to follow the law, as I said. You must follow the court's instructions. Okay, I want you to please use your common sense. We saw the sequence of events. We saw it on video. Is the video perfect? Absolutely not. Is it okay? Yeah. Yes, it is. And we're lucky to have it. There are 2 different camera angles from the I Promise School that show the sequence of events. And that sequence of events magically matches up exactly with what Ephraim and Mackay and Lamarion had to say about it. It also matches up perfectly with the debris field, the strewn about sandals, cell phones, wallets, IDs that we find, the broken Orbeez gun on the parking lot. It all matches up perfectly. There's a reason, because it does. Those things are in evidence. The crime scene, the photographs that we have. Okay, what is not in evidence? Statements by the attorneys. Okay, so if somehow one of the questions by the attorneys was that the Orbeez gun holds 20,000 pellets, that's not in evidence. You did not hear that from any witness. It's not in evidence. if somehow you gathered that there was a TikTok challenge, nope, not in evidence. Not a single witness testified that this was some challenge. It was a prank. Okay, the height and weight of Ethan was the subject of some debate. Anything other than what the ME said is not in evidence. Those are the only figures in evidence. Some notion that the confession is not real, that is not in evidence. No witness took the stand and said that's a false confession. None of that. The only things in evidence are the eyewitness accounts that show that Deshawn did it with his brother's help, and Deshawn's statement himself that he did it. This notion that because a couple of the boys mixed up the name of the first guy to come to the car is irrelevant. It is inconsequential. That is not a consequential fact. Okay. We talked about reasonable doubt and how you rely on it in your most important personal affairs. We've got the eyewitness testimony. We've got the videos that match up, that corroborate what happened. We've got all the evidence. We've got the ME, the medical examiner's testimony and his reports. You'll have those. They fall perfectly in line with what we were told happened. We were told by one of the defendants. Do not throw the baby out with the bathwater and buy into some weird notion of the slanted parking lot or the pothole or the false confession. It's absurd. No one testified to any of those things. When you retire to deliberate here shortly, I'm asking you to find the Stafford brothers guilty of their indicted offenses. Thank you.
All right, thank you, Mr. Kuhn. We have been going for almost an hour and 15 minutes, so before we proceed, I am going to give everyone just 10 or 15 minutes for a comfort break. We'll take a short break now. I did want to, before we do that, say to the people in the gallery that there has been a lot of in and out. Once we get started, if you do need to leave, you will not be permitted to come back in until there is another break. There is an overflow room that you can go into if you do need to leave. It is down this hall into the annex and down one floor onto two in the visiting judge courtroom right outside those elevators. So if you do need to leave in the middle of a closing argument, then proceed to the visiting judge courtroom until we take another break. At this time, we will take that short break.
All right.
Okay.
Really, it's over in June. I got a rib going for rape Chicago on Friday. It's stressful, but we're gonna have to rule on the motion either today or early tomorrow. I don't want to have it for this. I'll be scared too on Friday. How are you?
She brings the restroom. I'll check the hall again. Thank you.
Okay, please be seated. All right, Mr. Sin, you may proceed.
Good afternoon. The prosecutor had an opportunity to speak to you, and he spoke to you for about an hour and 15 minutes and told you a lot of things. And he said one thing only, that the defense agrees with. This never had to happen. What a waste. What an absolute waste. 1 minute and 15 seconds. That's how quick someone can lose their life over a prank. That's how quick 2 kids can be on trial for theirs. Half of that's out in the dark in the parking lot. My name's John Sin, and on behalf of Deshawn, I will apologize if I did anything or said anything that hit you guys the wrong way. I know I can be hard to take, but don't hold anything I did or said against Deshawn. He doesn't really have a say in this. He's living a nightmare. 15 months ago, Deshawn went out to play basketball. 9 days later, he got dragged out of bed by the U.S. Marshals Task Force and chained, naked to a table, no shirt, no shoes. For the last 15 months, he's still chained to that table. He's chained right here. He's chained to the table by a system that has to hold somebody accountable. Somebody has to pay. This case is difficult and it's evolved as we've gone. But no matter what the state tells you, no matter what the state says, none of this had to happen. And this nightmare that Deshawn and his brother have been living for 15 months, it's almost over. He's been waiting. They've been waiting for you to make sense of this. Make sense of the unsensible. What happened here? What happened when a beautiful, popular, promising kid dies. It affects the family, it affects the community, it affects the high school, it affects everybody. And there's a need to hold someone responsible. And that's why, after this happened, the police came out so heavy. That's why there are press conferences. That's why you heard about all this stuff about hate crimes and stomping to death and violent attacks. Things that we now know aren't true. We heard from the medical examiner, we've seen the evidence. What you thought you knew coming in, what we all thought we knew, none of that turned out to be true. Why? Why'd they do that in the first place? Because someone needs to explain the unexplainable. Someone needs to pay for what you can't pay for. It's a hard reality that sometimes you send your kid out on the first day of summer, the last day of school, and sometimes they get full of testosterone and THC, and like boys will do, they get up to no good, and they fight, and they punch, and they get punched, and 999 times you get your kid back, and every once in a while you don't. 1 in 100. 1 in 100, your kid hits his head in just the right way. And rather than say, man, that is just a tragedy, just what a waste. What a waste of a young life. What a prank gone wrong. Rather than say that, rather than acknowledge that sometimes you just can't make sense of things, they just don't add up, life's just not fair, someone's got to be blamed. So you drag them in and you chain them to a table. This investigation, this case, it evolved. We all did this together. We're all in this together. To me, these nice kids are clients, to the prosecutor of the cases, the judge, and the court reporter. We got court next week. To you guys, it's your civic duty. But to these kids, this is the most important day of their life. They've been in a nightmare, and you're the most important people they're ever going to know, because you got the keys to end this. Now, I know that we're throwing a lot of stuff at you, and I know that you're hearing all this stuff like self-defense and involuntary manslaughter. You're going to get the jury instructions, guys. You're going to have those. You're going to have all of this. You're going to have that in front of you when you go back there. But when we were promised this case, it was all wrapped up. The big bow on it. It was perfect. Cops got this horrible thing happened. The community is outraged. A good kid is dead. Let's find these animals. Let's go out there and grab them. And we grab them in. And 9 days later, it's all wrapped up. Wrapped up with a bow. And we came in here, we all thought we knew what happened because, hell, his friends told the police what happened. Deshawn made statements. It's all wrapped up in a bow 9 days later. And 9 days later, as soon as Deshawn got dragged out of bed, the investigation's over. Here's your case, wrapped up. And it sat for 15 months. And we unwrapped it together. And what did we find? Nothing. Nothing. The box fell apart. The case fell apart. 2 out of the 3 witnesses changed their story in a substantial way. We don't know what happened here in the dark. Have you ever heard that saying? What you do in the dark will be brought to the light. We've all heard that. But what does that mean? Who brings it to the light? Whose job is that? If something bad happened, if a crime was committed, whose job is it? Whose job is it to shine light into that parking lot so you can know what happened in those 30 seconds that are so crucial? This is the government. This is the police. This is the role they've chosen. This is the job they've got. They need to shine a light on this. You need to have a light shined on what happened in that dark parking lot. They're going to ask you for a conviction. And they're going to pretend like everything is normal, like everything happened according to script, like the fact that 2 out of the 3 witnesses can't identify the right person. I'm not trying to tell you that Deshawn didn't walk up to that car first. I'm not trying to tell you that Donovan did this. I can tell you when this first started, I would have never thought we'd be having that because I took the boys at their word and I read the police reports. Now I'm not so sure.
I object, Your Honor. Attorney Sims' sureness about the case is not a question for the jury.
Sustained.
You can't be sure. Why? Because everything changed. When I stood up here in opening statement, we talked about self-defense. We're going to talk some more about it. But the fact is, if 2 out of 3 kids can't even identify the first kid that came up to the scene, can you rely on anything they said afterwards? To just pretend like everything's normal, that that's the way it's supposed to be. They had a year to get this together. They've got a year, 15 months to prosecute these boys, to suck them into this system and keep them there. Because we need to keep them there, because someone's got to pay, and the kids don't even have their people right. Why? They're high. They're probably high. If they're not high, they're kids and they're scared. And everybody's scared about what happened, and everybody starts lying. And you start hearing about a pounding ground, pounding ground, pounding ground. Funny the medical examiner didn't see that. We have medical testimony. How is that possible? This was a stomping. Ethan was stomped to death. His head was caved in. Brain matter spilled in the parking lot. Is the medical examiner lying? Shouldn't we be happy that Ethan isn't the victim of some horrific hate crime? Shouldn't we be happy that the medical examiner says that he's got 2 punches and maybe a kick to his body and that's it? He's not beaten from head to toe and stomped to death by violent, crazy people that don't wear shirts and don't wear shoes. These 2 kids weren't looking for trouble. Trouble came looking for them. Everybody started. Where's Donovan? Where's Donovan during all this? How did Donovan get out of this? How did the other boys in the car get out of this? Who started this? When they left the house that night, Deshawn was doing what older brothers do. He steps up. He looks out for his brother. He looks out for his cousin. He did it that night. He did it in the interview room when he protected Donovan. They want you to believe that in the interview room, everything he said was a confession. And frankly, we started off talking that way. But who knows at this point? Who knows if he's covering for Donovan? They had 9 days of reading about this case in the paper, and he had 90 minutes sitting tied to a chair with his shirt off, with his head down, trying to think about how he can dodge this bullet, how he can avoid getting sucked into this system, how to keep his brother out of it, how to keep Donovan out of it. So I submit to you, we don't really know what happened here. All those witnesses on their side, they're unreliable. How do you know it? What they say doesn't make sense. There's no evidence supporting a ground and pound. There's no evidence no evidence supporting any of those things. They can't even get the basics right. These kids are doing what kids do. But we got to talk about Ethan Limey and what a good kid he is, and I get that, but what was he doing that night, and what's his state of mind? No one's trying to tell you that this is a real gun. We're not trying to say that. I think it's pretty clear. For a hot minute, everybody thought it was a real gun. But let's talk about Ethan and Akron and what their night looks like. It's the last day of school. Summertime. Ethan and Ephraim are making plans, and they're nice kids, and they're doing what kids from that your kids with nice families do. They're going to go out. They're going to have fun. It's warm out. They're going to smoke some weed. Ethan's going to sell some weed. He's going to show off a little bit. And he tells Ephraim, get your splatter gun. Why? What's the point of that? Why get your splatter gun? Because it's going to be a fun night. And then when Lamari and Mackay come out of the house, they get hit with the splatter gun, and they're not mad because these are their friends. But Ethan's already ready to have some fun. He's ready to have some fun. They brought the splatter guns. They're going to shoot the splatter guns. And they shoot them at their friends, and now everybody's on board. And Ethan is the star of the show. He's driving the car. He's got the weed. He's going to drive you to I Promise School, and he's going to hand you the gun and tell you to get up and do it. And they did it. And all Amari and Mackay wanted to do was just stay in their house. They don't know these guys like that. Ethan and his sidekick Ephraim, they don't know him like that. They wanted to just go in the house, but they went along with it. And they went along with it. They went along with this idea, let's shoot at some people and let's make them believe it's a drive-by. And it ain't that funny. I mean, depending on what side of West Market Street you grow up on, it's not that funny. It wasn't funny to these kids. It was mean-spirited, and it was bullying, and it was mean. Say what you want about who's bigger and who's smaller. These guys are small. And I don't know why Ethan's driver's license says he's 6'1". I don't know why the police department says he's 6'1". I don't know. But I know these guys are 5'5". I know they're the smallest kids there. I know that it's 4-on-3, and I know that these kids were playing basketball. That's all they were doing. Ethan pulls in. He's in that state of mind. They've all smoked a blunt and a half. And no matter what Ephraim says, oh, I don't get high off a blunt and a half. I have a perfect memory, and it's the wrong guy. Mackay was pretty straightforward. The last kid you heard from, he seemed pretty straightforward. He seemed like he just, to me, he came in and said, yeah, blunt gets 4 people high. Sure it does. That's the purpose of it. So you got 4 high kids with paintball guns out to bully some other kids. And they're going to pull up, and it's going to be a big prank. And it could have been. It could have been hilarious. Well, it didn't have to be deadly. It could have been right out the window and go forward. That's what they thought they were getting into. But that wasn't Ethan's choice that night, because Ethan is on his first night of summer, and he's having fun, and he's showing up for some friends, and he tells them to get out, and they get out, and they shoot these kids, and these kids run for the gate. And you can see the kids in the car didn't stay, they blocked the gate, they ran up there. So as these kids are running across the court, their exit way is getting blocked. That's a little scary. No one's trying to say they thought it was a gun the whole time. But what I am trying to say is, you got a right when someone shoots you with this damn thing to go, are you serious? Are you serious, dude? Come on. Am I being pranked? Is Ashton Kutcher going to jump out on these kids and tell them they're on Punk'd MTV? No. They don't know what the hell's happening, but it's reasonable that someone's going to go up to them and say, what the hell? What the hell? And that's where Ethan could have drove away. That was a choice he made, to drive away. Could have done that. That was the plan, man. What's the purpose of getting out? I think the prosecutor will tell you the purpose of getting out is to let him in on the joke. Guys, be cool. It's a joke. It's a prank. You know, we're just playing. Is that what happened? No. Sean walks up with a basketball in hand. And what he gets is shot in the face. Shot in the face. One time, every time you hear this thing make a bump, how many seconds did it take for Deshawn to walk up to Ethan? How many rubber bands did he take to the face? You don't think that gives you a right to grab the damn gun? Ethan's smiling. He's smiling. And they're going to tell you, he's smiling because it's so funny to everybody. He's smiling because he's a smiler and it's so nice and everything. He's smiling because it's mean. He's smiling because he's shooting this kid in the face. What's going through his mind? It's the first night of summer. He's full of THC and testosterone, and he's a boy. And boys do what boys do. And who's going to think that on this night he's going to hit his head in just a certain way and not come home? Sometimes these things just happen, and sometimes there just aren't answers. The prosecutor stood up here doing his job and telling you that everything is normal and everything's fine. And they're going to pretend like they've shown you a light, that they've lit up what happened in that parking lot so you know. You know what happened in the dark. You know it. You have to know it, right? You heard from 3 high kids who couldn't get their story straight. That shows you what happened in the dark. And they want you to pretend that you saw it and pretend that you're as confident as they are as to who did what in the shadows for 30 seconds. And they're going to spend a lot of time talking about Donovan kicking a window and what happened after. And you know, Ethan's gone by then. That stuff's horrible, but it played no part in this. You've got to look at what killed Ethan. A punch. Presumably a punch. We saw 2. The medical examiner did not say Ethan was beat horribly. He said he had a hit in the eye, a hit in the mouth, and something on his side, and bloody knuckles. That's it. That's not consistent. These kids said ground and pound. I don't know if anybody knows what that means. Ground and pound. Over and over. He was violently stomped. Come on. Come on. Medical examiner in on it too? Come on. That guy had no motivation to tell you what it is. This is a horrible tragedy. And we wish we had answers, but we don't. You're going to get jury instructions. And I'm going to tell you about these things because I could talk all day about reasonable doubt. And reasonable doubt, are you firmly convinced? Reasonable doubt is you have to believe they proved their case. They proved that Deshawn is the one that caused Ethan's death. They proved it. They have to. That's what you got to believe. And further, not just that, they're going to prove that Deshawn didn't act in self-defense in the shadows. That's on them. I don't know what happened there, and I'm not bothered by that because it's not my job. I'm bothered by the fact that they don't know what happened out there. And they want you to make a decision to chain these kids to this system when you don't know what happened out there. It's their job to shine light on it, and they didn't. Reasonable doubt. Reasonable doubt is you must acquit unless the state of Ohio proved to you each element of defense beyond the reasonable doubt. And reasonable doubts where you're firmly convinced of the truth of the charge. You're so convinced that you'd rely on that decision even if it was your own life, your own affairs, your own kids sitting in that chair. You know it. You're firmly convinced that Deshawn attacked Ethan, assaulted him, took his life, and he didn't do it in self-defense, and that's been proven to you. Come on. Saying it doesn't make it so. There are jury instructions. And I talked to you in my opening statement about how you do a case like this when you've got all this pressure from family and friends and Ethan's family and Deshawn's family and the cameras. How do you do it? Do you just go with your gut or decide? That's part of it. But it's a math problem too. You got a math problem. You got to work the equation. These are jury instructions. She read them to you. The judge And maybe you're better than me and you understood every one of them and you know exactly what was said and who. I don't. I can tell you though, you're going to go back there and you're going to do the math. And you're going to hear some things about what they had to prove in order to successfully bring these kids into the system. What do they have to do to get their conviction? We don't have to do anything. We don't have any burden whatsoever here. We don't have to do a thing because if they're going to make these accusations on behalf of the government, then they need to bring some proof. They need to shine that flashlight. And again, I submit to you, this investigation was terrible. Nice guys, nice people. You don't check a cell phone? You don't turn on a cell phone and see what was said? This investigation was closed 9 days later. They got Deshawn, they locked him in a room, they got his statement, and we're done. And we don't want to hear anything to the contrary because everybody's happy now. The chief's happy, the family's happy. We got the bad guys. We got them. Ethan's a victim here of these rotten kids who are waiting for someone to stumble onto their turf. That's the implication. Stumble onto their turf and get killed. That ain't what you heard. That ain't what you heard. What you're going to hear is the stretch that the prosecution has gone to try and get some charges to stick. You're going to get these jury instructions and they're going to talk about who's got to prove stuff and reasonable doubt. And I'm not going to spend a ton of time on them, but I'm going to talk about cause. In order to establish involuntary manslaughter, they have to show that Deshawn caused Ethan's death. Cause. Cause is an essential element of the offense. Cause is an act that in a natural and continuing sequence directly produces a death without which it would not have occurred. Do we actually know what happened here? I get that the prosecutor thinks that we're full of BS talking about a parking lot. May or may not be right. But the fact is, Ethan's backing up. People are saying Donovan's punched him. None of the kids, none of those witnesses from them could say Deshawn did it. The only one saying that Deshawn did it is Deshawn. And we know he's covered for Donovan. But who knows? It's their job to show it to you. Did they trip and hit his head backing up during the fight? I don't know. Probably not, but there's potholes there. Say what you want. Did see the pictures. Did someone else knock him out? Who knows? Come on, how come none of the boys saw that? What's up with that? You see everything else, but you can't tell us who saw it, who hit him? What did they see? How high were they? Where were they sitting? Cause. You have to be firmly convinced. You have to know that Deshawn threw that punch. You got to know it. And at the beginning of this case, before we unwrap that empty box, I would have said, yeah, absolutely. It's a self-defense case. Of course Deshawn did it. Who knows what happened in the dark at this point? But I submit to you, if you don't know, that's reasonable doubt. Basically, as you dig through these things, you're going to hear that Deshawn's charged with involuntary manslaughter causing the death. And you're going to hear that he's in charge with it 2 ways, one by ag assault, one by assault. I'm going to talk about that for a minute, but cause is the first thing. You got to get through that. If this were a regular case, the state's got to prove it. They put on the evidence. If you think that Deshawn threw the punch, then he caused it. That does not mean he's guilty. Not in the state of Ohio. Not in the state of Ohio. In the state of Ohio, under Ohio law, a person is allowed to use force in self-defense or in the defense of another. You're allowed to do that. You don't have to back up from a fight. They must prove that he wasn't defending himself. Now, when you read the jury instructions, you're going to hear about self-defense. And again, not only do they got to prove that Deshawn committed this crime, and Tyler committed a crime, they got to prove that they weren't defending themselves. And I submit to you, that's going to be a very high burden. But you're also going to hear some law, and I know the jury instruction explained it, but I kind of want to hit on something with you. There's a different kind of self-defense to use deadly force than there is for regular force. And what do I mean by that? Deadly force is defined as any force that carries a substantial risk. It will approximately result in the death of a person. Substantial risk means a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur. What I'm saying is, I don't know that a punch is deadly force. You don't look at the end result. If I did my little rubber band stunt here and this glass falls over and stabs one of you and breaks on you, that doesn't make the rubber band deadly force because you died. It's about whether or not there was a known risk, whether or not it's foreseeable, whether or not that if you punch somebody, you're going to kill them. And 999 times it doesn't work that way. They don't hit their head that way. But the reason it's important is because you don't get to respond. You don't get to respond with deadly force anytime. You can't bring a gun to a knife fight. It's not as important in this case because if Deshawn used deadly force by a punch, which I submit to you, it doesn't make, that's not what it is. But if Deshawn did it, then Ethan did it too. It's all about proportional, being reasonable. You respond you can respond proportionally. The judge is going to give you a jury instruction on that. A person is allowed to use force that is reasonably necessary under the circumstances to protect himself from danger. So here's what we're getting at. Did Deshawn use deadly force? If a punch is deadly force, then I submit to you he was facing deadly force. If a punch isn't deadly force, then he wasn't facing deadly force. The reality is he met a punch with a punch. He met getting shot in the face with a dozen rubber bands with a struggle. That's reasonable. That's not bringing a knife to a fist fight. That's not what the law is talking about. These boys fought, and no matter how you look at it, the state of Ohio has not proved that this wasn't self-defense. And that's their burden. You heard, Deshawn's big brother. They're minding their own business. They even say they're minding their own business. They're minding their own business. And no matter, you can drag them out shirtless, you can chain them to the table. These are nice kids, and he's a big brother, and he looks after his little brother, and when Tyler says, Sean, when Deshawn's been hit his head to the point he throws up, struggling with Ethan, and now Ethan is getting ready to go after Tyler. Think about whose state of mind is whose that night. These boys are playing basketball. Again, they brought a basketball. The other kids brought this. Look at their state of mind. Ethan got out of that car to do what? To fight. To fight. It's the first night of summer. That's what boys do. It's what boys have always done. And when he went after Tyler got put to the ground. He went after Sean got put on the ground, or he hit his head. Then he turns on Tyler, and now this kid says, Sean comes up, and if you believe one of the witnesses, not the other three, either Sean or Donovan punches Ethan, and that's it. That's the end of the story. That's the end of the case. And the question is that self-defense? Is it defense of another? You can defend yourself and you can defend your family. That's what we're saying here. That even if they prove to you that Sean threw a punch and that punch caused Ethan to hit the pavement and that pavement cracked his head in just that right way that we don't get him back, that's self-defense. Because these boys were minding their own business when trouble came to them. you're going to hear a lot about what happened after Ethan went down. And the medical examiner said he's gone. And they want to talk about punches and kicks and ground and pound. And I'm not saying that none of that happened. But I'm saying the medical evidence is what the medical evidence is. If you hit somebody, there are marks, and the medical examiner can count them out for you. And we're not talking 10 minutes. We're talking, how much time? A minute and 15? How long did it take for the kids to walk out with a gun and walk back? And then how long were they in the dark? How long was 30 seconds? 30 seconds in the dark? That's how quick you lose your life over this nonsense. That's how quick you can be sucked into a system. Nonsense. One minute, 15 seconds, and we don't know what happened. All we can do is try and put the pieces together. But you know what? This isn't a puzzle that you guys have to solve. This is a puzzle they have to solve for you. You don't get to guess what happened in the dark. You have to know what happened. Someone had a job to show it to you. You would have liked to know what was on those cell phones. Don't tell me you wouldn't like to know. You would like to know what these kids said before and after. We could have done that. These two kids aren't charged with an investigation that was closed 9 days later. How much did we not hear about? This has been a rush to judgment. You know, that first round, that minute and 30 seconds, the first round where Ethan lost his life, everything after that is really not relevant, and that's all they want to talk about because it makes you think. It's like a paintball gun found in a car a week later. You're supposed to read something into that. Pockets pulled out, and you're supposed to suggest, oh my God, they were robbing him. They're robbers too. Why are they so desperate? Because someone's got to pay. Kids like Ethan don't just crack their head and die. And when they do, like I said, I'm not for everybody. But you can work the math problem. That's all we are asking you to do. Work the problem. Read the jury instructions. Use your common sense. And all anybody can ask of you is to speak your heart. Do the right thing. Do the right thing. No one's looking for sympathy here. No one's looking for you to ignore the law. I'm the defense attorney, and I'm begging you, follow the law. Follow the law. Because if you do that, you can come back here and you can say, this was a tragedy, a preventable tragedy. It didn't have to happen. But we've already lost one young man. We don't need to lose another two. We don't need to lose another two.
Your Honor, I would object to that characterization.
Sustained. Ladies and gentlemen, you will be instructed that the issue of punishment is not to be considered. The court will decide punishment if there is a guilty finding on any of these counts. Mr. Sin.
I know you don't want to hear me drone on, so I won't. This isn't a popularity contest. This isn't about those guys on TV or the pressure on these guys or the police. It doesn't mean you're not pro-police. It just means that you were supposed to get answers. You were supposed to be shown what was in the dark. And it's darker now than it was when we started. You got nothing but questions. And questions are doubt. And if you don't know what happened in the dark, then don't let them ask you for a conviction because they didn't give you what you need to do it with a straight face. You got to live with this. They got to live with this. And if you follow those instructions, you can live with this. Because the instructions will take you to the right answer. And the right answer is these boys are not guilty. These boys acted in self-defense. Thank you.
Thank you, Mr. Sin. Mr. Gallick?
Thank you, Your Honor. May it please the court, opposing counsel, ladies and gentlemen of the jury. As you know, I'm Donald Gallick. I represent Tyler Stafford. And I have a few things to say. I mean, the bad news is you have to listen to 4 closing arguments. The good news is I'm number 3. I know this trial has been difficult on everyone. It's been probably more difficult for some than others, but it's been tough on everyone in this room to one degree or another. I want to say that the kids are not all right. And Prosecutor Kuhn brought up that some of them called them boy or boys. I did not. I didn't call anyone here a boy or boys. But I have called a lot of people probably kids. And you can say, well, wait a second. Weren't they 18 or 19 when this thing happened? And Ethan Lyman, he was 17, so that's a legal distinction, I guess. To me, they're all kids. The difference between a 17-year-old, an 18-year-old, 19-year-old, 20-year-old in our culture, I don't know what the difference is. Our culture is in a lot of trouble, okay? There was a time in this country, not 2023, but let's say 1953, you could go into a high school and kids would get in trouble for not bringing their rifle to school. Wait, what? High schools would have marksmanship classes. High schools would have shooting training. Boy Scouts used to have rifle training. What? That sounds crazy. Well, it was a long time ago. It was a different culture. Could you imagine that in 2023? Having a 17-year-old bring an actual rifle or any kind of dangerous device to a high school? You certainly couldn't even bring this into a high school today. I mean, perhaps at some point we won't allow people to have butter knives until they're 25. I don't know. But our culture's in a lot of trouble. And it was brought up that, well, you heard testimony that TikTok didn't have anything to do with this or anything like that. The 3 kids, as I'm going to call them, who were with Ethan that night, they said, oh yeah, I know about TikTok and I know about social media. They all do. Every kid in the country, probably over the age of 7, knows about social media these days. Was that an influence on what happened here? That's for you to decide. Now, I want to go over some of the witnesses that you heard. Because Prosecutor Kuhn said everything lines up. We know what happened. We heard from the witnesses. Everything lines up. Maybe things didn't quite line up like he said. Now, I mean, Ephraim, his father testified. He was not there when it actually went down, but shortly thereafter. He sees his son, 9 o'clock, or I think he said 9:30. He's leaving the house. Ethan's coming to pick him up. He's got one of these guns. And you heard me ask him, was that concerning to you? No, I wasn't concerned. Your son's leaving, getting in Ethan's car with one of these splatter guns, going, you don't know where. No, I don't know where. Does your son have a curfew? No, he doesn't have a curfew. Goes wherever, does whatever. Okay, that's fine. And then you heard his son come up and take the witness stand. And he said, I had a little bit of marijuana. Okay. Did that marijuana affect you? It doesn't really affect me. Oh, does it? No, it doesn't really affect me. Okay. Then he said, well, actually, it kind of makes me tired. Okay. Then I asked, well, what about this video where you're running up and chasing Tyler and Deshawn with the weapons? Well, I didn't have that much marijuana. If I did, maybe it would have made me tired. I mean, that was his testimony. Now the prosecutor, in his opening statement, he pointed out, did you notice how scared Mikhail and Ephraim were when they were running away from Tyler and Deshawn? The testimony that we saw was the only one chasing them was Donovan Jones. The larger person, the guy who's almost 6 feet tall, The guy who was shirtless that night, not the person who was shirtless when he was pulled out by the U.S. Marshals, that was Deshawn. Deshawn didn't have a shirt on, I think, when he was chained to the interrogation room. But on the night of June 2nd, 2022, the testimony was it was Donovan Jones who was shirtless. It was Donovan Jones who was chasing people. The hunters became the hunted, as it were. Now, when Ephraim testified, he said Ethan was throwing punches to defend himself. He said it looked like a ball of people. There were people fighting all over the place. Wasn't really sure who was who. But his testimony was clear. And I think, to go to Mr. Sinn's point, if a punch is deadly force, then there's a lot of people using deadly force in this incident, including Ethan. Now, Mr. Dancy testified, and he said he didn't seem that interested in being into this night out and this prank. But he brought up that he thought they were just going to do, his words, a quick drive-by. Maybe I'll take this, and maybe I'll lean out the car. Maybe that's what we're going to do. And we'll shoot at some people, we'll laugh, and we'll drive away. But Ethan changed the plan. That wasn't Ethan's plan. Maybe it was Mr. Dancy's plan. But that's not how it went down. Okay? He said that he saw Ethan give his gun to Mackay and told him, get out and run up on him. Run up on him. Chase him down. Why? To panic him. To scare him. Right? Apparently in 2023 we don't have enough panic in the world. We're going to scare him. Okay? And that's what happened. And then Prosecutor Kuhn said, well, they didn't expect a response. You didn't expect a response? You don't expect a response at 10 o'clock at night? You're in the dark, you run out towards a basketball court, and you start shooting them with these things? You didn't think there'd be any kind of response? That doesn't make sense. That doesn't make sense. They do respond. They run out, and the testimony that you heard from the three people who were there, the three people who were in Ethan's car that night, some testified that it was Donovan who came up, some testified it was Deshawn who came up. Coming up, swaying, ready for a fight, that wasn't the testimony, was it? The testimony was Donovan or him said, hey, are you serious? Like, what's going on? What's going on in our community? And you heard one of Ethan's friends say, well, he kind of took that to mean, there's a lot of violence going on around here. We're having a really difficult time these days. This is not the kind of thing that we need to have. We don't really need to, that's implied, but that's how the witness interpreted it. Who knows what was really meant? The important point is that when Donovan or Deshawn came up after being shot, just want to talk. Maybe Donovan or Deshawn was looking for an apology. I don't know. But what they got is shot in the face. And then it changed, well, yeah, I said shot in the face, but maybe it was shot in the torso, or maybe it was shot in the neck. Let me see if I can change this testimony around a little bit. Shot in the face, or the neck, or the torso, or whatever we can do to help the prosecution. We'll change it around a little bit. So then at that point, it becomes a fight. And who threw the first punch? Did we get testimony on that? I mean, what does your memory say? You heard testimony that it was a mutual fight. They said, oh, you don't call it a fight. That's not right. That's offensive. Well, that was the testimony of the people who sat in this chair. I wasn't there. He wasn't there. They weren't there. The people who testified from this chair who were there said, yeah, it was a mutual fight. Ethan was throwing punches to defend himself. Ephraim said there were so many punches that just looked like a ball. He didn't know who was fighting who. But the question is, if you get punched, is it reasonable to punch back? If you get shot in the face with one of these, the second time you've been shot with this in a matter of 20 seconds, however long it was, is it reasonable to respond? Is it reasonable to walk up and say, hey, what are you doing, man? Are you serious? And then, instead of an apology, you get the gun put in your face, or your neck, or your torso, depending on what part of the witness testimony you want to believe. And you get more rubber bands, the sensation of rubber bands in your face. Is it reasonable that turns into a fist fight? Use your common sense. Use your common sense. Now, Any testimony that, oh, well, Ethan wasn't looking for a fight that night, is that what the testimony suggests? You heard testimony from, I think, Mr. Shady as well, saying, man, hurry up, we did our prank, let's get in the car, let's get back in the car and get out of here. Time to go. No, Ethan didn't want to do that. He wanted to stay there and continue the prank or whatever we're going to call it. Now, you've heard us say from day one, this is a self-defense case. That my client certainly didn't start anything. The testimony that you heard, Deshawn didn't start anything. Maybe Donovan Jones started something, but he's not here. Tyler Stafford was trying to either defend himself or his brother that night. And unless the prosecutors prove otherwise, it's a not guilty verdict for all of the counts. But I want to talk about one thing in specific, and that is, specifically, Tyler is accused of involuntary manslaughter. And you have the jury instructions on all this. You'll be able to see it. The medical examiner's testimony was very clear. The cause of death was the injury to the back of Ethan's head, okay? All the other things are horrible. You shouldn't kick someone, that's horrible. That wasn't the cause of death, okay? It's probably not good to have a bloody nose. That's not the cause of death. The suggestion that it's ground and pound, that he was down on the ground and getting punched repeatedly, the medical examiner said, well, medical examiner wasn't there, but he goes, here's what I know. He said he didn't have a broken nose, he didn't have a broken orbital bone, he didn't have any broken bones in his face. So if that would happen, if there was someone had him on the ground, unconscious and constantly pounding him, and not even break a bone, use your common sense on that, okay? The medical examiner said once Ethan went back and hit the pavement, that injury to the back of his head damaged his brainstem, and he was probably gone within minutes or even seconds. You heard the medical examiner say, I asked him, well, what if there had been an ambulance around the corner? He goes, probably wouldn't have made a difference. Okay, it probably wouldn't have made a difference. So that's awful, it's horrible, but that's the evidence that you have. That's the facts that went down on June 2nd. And we certainly don't like it. We're all horrified by it, but these are the facts that you're given. And we can't interpret the facts differently. We can't make up facts. We have to take the testimony of the medical examiner. No one contradicted the medical examiner. No one came in and said, well, actually, he was wrong and he did the autopsy wrong. That's your medical testimony. The injury to the back of the head is the only thing relevant on a manslaughter case because he said that's what caused the death. Now, there was some testimony maybe that Tyler might have been swinging at Ethan. Where did Tyler hit Ethan? Don't know. Did Tyler hit him in the arm? Did Tyler hit him in the leg? There was talk of one kick. I don't think you heard testimony that Tyler did that. You heard testimony that Ethan had wounds on the top of his foot. Was that due to him kicking someone? Don't know. You have to figure that out if you find that it's relevant. But you heard me ask witness after witness, do you have any evidence that Tyler Stafford caused anyone's death on June 2nd? Was there any testimony? Was there any physical evidence that Tyler Stafford did anything to cause anyone's death? And no answer. No. Don't have anything. Then I asked Detective Hornacek here, who I think was our last witness. And I asked Detective Hornacek, I said, hey, lawyers like to repeat themselves. I keep asking the same question of every witness. Do you have any evidence that Tyler Stafford had anything to do with causing anyone's death that night? And Detective Hornacek told us, well, there was a statement originally, going back, 15 months ago, whenever, that all three jumped him. And so there you go. Wait a second. So all three jumped him, and so all three of them committed the manslaughter. Was that the testimony? That doesn't make sense. That's not what we were told in opening statement. That's not what we've been told throughout this whole trial, but it's like, well, plan A didn't work. We can't get a manslaughter conviction on Tyler that way. We'll try this way. Well, that didn't work. Okay, well, all three jumped him, so I guess all three of them committed the manslaughter. Well, that's not what you were told in opening statement. And now, today, you're going to hear jury instructions. I think you heard it from the judge, that it's like, okay, well, you know why Tyler is Well, he was complicit. He helped. He was there. He was distracting Ethan during the fight, something like that. It was complicity. No, you know what it was? Maybe it was conspiracy. Maybe we put conspiracy in the jury instructions. Well, wait a second. Where did that come from? Did you hear any witnesses about that? Did you hear any witnesses say there was a conspiracy? Did you hear any witnesses say there was complicity, that Tyler was complicit and was helping Deshawn cause his death? No. Well, why are we talking about that today? Well, we got to find some way to get a conviction. We got to come up with some theory. The evidence doesn't match. The witness's testimony doesn't match. The three witnesses don't know who did what. As Mr. Sin told you, two of them said it was Donovan Jones. Well, that's misidentification. I don't know. We kept asking them, is it the taller guy? Yeah, it's the taller guy. That's Donovan Jones. Right. Yeah, you're right. The taller guy is Donovan Jones. He ain't the taller guy. And he ain't the taller guy. Donovan Jones is. Yeah, that's the guy who was chasing us. That's the guy that came up and knocked Ethan on the ground. Another thing you had is, we were told in an opening statement that it was one punch, and he went down to the ground, and that was it. He went down to the ground and no more. But now you've also heard, now wait a second, Deshawn's statement, he grabbed him like a wrestler and slammed him down on the ground. Actually hurt his head, he slammed him down there so bad. And then Ethan got up, and then he got hit again by either Donovan or Deshawn, and he went down a second time, and that's what killed him. Which story is it? Which story is it? Did he go down once and that was it? Or did he go down once, get up, and then someone came by and punched him and knocked him down a second time? You've heard a lot of different versions on that. The truth is they don't know. Nobody knows. Nobody knows. But the only thing that matters is that injury to the back of his head. And no one has testified that Tyler had anything to do with it. And today we're told, okay, he didn't have anything to do with it except he was complicit or he committed a conspiracy. And this is the first time we've heard that this entire trial. And I'm going to sit down soon. Hopefully she will explain why that's a new thing coming up today. We haven't heard it at all.
Your Honor, I'm sorry to object during Attorney Gallick's closing, but I don't believe that is an accurate statement of the law, Judge.
Well, I did not instruct as to conspiracy. I did not.
Conspiracy is not in the jury instruction?
Correct.
Everything I said, aiding and abetting and complicity. Maybe they will explain why that's coming up today. Thank you, Your Honor.
Ladies and gentlemen, as I have discussed a few times and everyone has made clear, it is the state's burden of proof, and because it is the state's burden of proof, they do get the opportunity to rebut the closing arguments of the defense. They do have the opportunity for the last word. So I'm assuming, Ms. Schucke, you are going to present the rebuttal argument.
Ladies and gentlemen of the jury, I kind of want to bring us back to focus. Bring us back to focus on your jobs here, what you have heard, because I'm not sure, I think the word was the prosecutors are, that we pretend, we present you facts through the evidence, through the witnesses. We're not giving you anything that you have not heard from that witness stand. And you have to listen to the things that come from the witness stand. You can't, as the judge just said, what we say is argument. In our questions even, it's our questions are not facts. So if you didn't hear it coming from a witness on the witness stand, you cannot consider it. It's the witnesses and the evidence that you heard that you need to consider. Okay, so right away you heard this had nothing to do with an Orbeez TikTok challenge. You had no evidence that the orgies were frozen. Those are things that the attorneys state in their questions. But that's not evidence. The evidence comes from the witness stand. So I just want to refocus you back on that concept. So I have to sort of address little things that come up, right? I'm trying to hit things. I may not hit everything in rebuttal, but this is our opportunity for rebuttal. I want to go first to the medical examiner. The medical examiner stated in a question or an answer, yes, this could have been consistent with a punch to the mouth, one punch. This could have been consistent with a punch to the head. But he didn't say it was only one punch to the head and only one punch to the temple. It could have been consistent with numerous punches. So you have to remember, look at your collective memories. But from the evidence that you heard about the fight that occurred, how many punches were thrown? You can look at the evidence to his body, to Ethan's body, to help you figure that out. But you also have the boy's testimony. And we don't, as prosecutors, tell our witnesses what to say. We try to remember, tell the truth from what you can remember. We don't tell them what to say. They're trying to, these boys coming in here in front of everybody here and trying to tell you what they remember from about a year ago, more than a year ago, when their friend died. When Ephraim's very good friend died. And we talked a little bit about it in jury selection. What could affect somebody's memory of an event? We talked a little bit about, how long the event happened. Was it really short? Was it very long? Was it traumatic? All those things could affect someone's ability to remember. Fear could affect someone's ability to remember. Nervousness up in court could affect somebody's ability to get every single thing correct. But we do know that all three of Ethan's friends, at first, in talking to the police, indicated and had been consistent with the fact that this was a 3-on-1 fight. That is not disproven anywhere in the evidence. All three of them said that. So that's definitely a consistency. And they described the main, person who came over first as the guy with the dreads with the tints on the end. And we know from the evidence that was Deshawn Stafford that came over first. How else do we know it wasn't Donovan Jones that came over first? You have the video. And the video shows he's the tallest one. And you're going to watch this video. I know you will. He's the tallest one, and he's not the first one that walks over. The tallest man there is Donovan, and he walks over to the car, to Ethan's car, last. So we know for a fact from that evidence alone that Donovan Jones is not the one that goes over and confronts Ethan. And we also know it from Deshawn's statement to you. So we talk about self-defense. Self-defense, as the judge is giving it, is going to instruct you, has instructed you, defines a different type of force that can be used. And one thing that you don't have here is a toy gun is not deadly force. The instruction reads basically that the defendant, in this case I'm talking about Deshawn, he did not have reasonable grounds to believe he was in imminent danger of death or great bodily harm. We submit to you that he did not have, that was not reasonable. It was not reasonable to think that a toy gun is something that you have to respond to with some kind of deadly force. And let's talk about how that went down. We all, from the beginning we've owned that this prank that these kids did was a terrible thing. And Deshawn is upset about it. He goes over to Ethan and confronts him. We're not anywhere near self-defense here at all. He is going over there to confront Ethan. And maybe you think that's okay. Maybe you think, yeah, that kid should have gotten confronted. They should have been able to confront them about doing that stupid prank and shooting at them. But Deshawn made a choice to go over there to confront him about it. And we know that he is shot in the face, or shot in the chest, wherever he's shot, and he grabs the gun and he breaks it. Because you see it in the evidence that we submitted to you, in the pictures, it's broken, it's on the ground. He grabs it from Ethan, he throws it on the ground, and it's broken. Okay, let's go. I broke your gun. Jerk, why'd you come shoot at me? I took it, I broke it. I'm gonna walk back to the court now. No, that's not what he does. Now he punches him. Now we have a one-on-one fight. And again, if you want it, it's your choice as jurors to believe that, okay, maybe you should have punched him, okay. But that is a one-on-one fight. But it does not stay that way. It escalates. Tyler's got to run over and get in the fight. Donovan's got to run over and get in the fight. How is that now a fair fight at all? It's not. It becomes an attack. Because now there's one person trying to fend off 3 people who are punching at him. It's Ethan who's walking backwards away from his car because they're coming at him 3-on-1. That, I submit to you, is where the self-defense argument falls away. It's 3-on-1. The victim is backing away. He's being sort of basically forced away from his car. He's kind of sort of, back there can be a getaway car, right? Let's hop back in and get out of here. But it's 3-on-1 coming at him, and he can't get back to the car. The defendants, there's the statement that they have to be, that serious physical harm is what is being caused here. And I submit to you that when Deshawn, Stafford, and Tyler are fighting and punching at Ethan, and he falls on the ground and gets knocked out, and Deshawn gets on top of him again and is punching him on the ground, way beyond self-defense. Way beyond self-defense. It's not self-defense at that point at all. The actions of the defendants during and after Ethan is knocked out, you need to look at that. We talked about what's going on in their heads. What are they thinking? You can look at their actions during and after the incident to see what they were thinking. And what do? After he falls to the ground and he's punched out, he's knocked out, they continue to retaliate. That's the word my co-counsel used, and I think that's exactly what happened here. They were retaliating because they were shot at by the Orbeez with the Orbeez guns. They were retaliating by going after Ethan. They were retaliating by grabbing phones and smashing phones and getting in the car and driving it away like Tyler did, getting a phone from the car and throwing that phone on the ground. That's not self-defense. That's retaliation. They were angry at what happened. They were shot with an Orbeez gun, and they retaliated. Not self-defense. The Lamarian's testimony, he told you it was a 2-on-1 fight. He said it was the brothers, meaning the Staffords. The one with the color in his hair knocked him out. There it is. Lamarian said, and he had gotten out of the car, if you remember, and gotten a little bit closer to the fight to try to help until he was kind of like taken aback when one of the Staffords was going to maybe go after him. He was closest to the fight at that point, to the attack at that point, because that's what it was at that point. And he said the one with the color in his hair knocked him out. And we had testimony from detectives in this case that that person was Deshawn Stafford. So right there, Lamarian tells you who punched Ethan when he went down to the ground. Lamarian said Ethan was just trying to defend himself. And in fact, that's exactly actually what Mr. Gallagher said at one point in his closing argument. Ethan was throwing punches to defend himself. Yep. Lamarian says both of them, both brothers, start stomping him. They're all stomping and kicking, punching him while he's on the ground. And it was Lamarian's statement about the ground and pound. And we said, what is that? And basically getting on top and punching him. That they're still doing that. He also said, Lamarian, that at the end, one of the two kicked Ethan really hard. Extra hard, were his words. That they kicked him then, as he's on the ground, bloodied, as you have seen in the pictures, and they walked away. Serious physical harm. That's how he looked when he got on top of him to start knocking out the blood on his chest here. Okay? He got the spit up blood, but his eyes and his mouth and his face looking like that when he got on top of him and continued to punch him. Knowing that you're going to cause, that serious physical harm has happened. Taking me back to the photo of Ethan with the mark on his chest area there, on the side, his flank. Consistent, as we know, with some kind of imprint from a blunt force trauma object. And you'll get this, and it's never really great on the photographs here on the screen, but you're going to get it, and you can look at it, how it actually comes to kind of like a point. Medical examiner said consistent with like a sheet print. So Lamarian says, they kicked him. After the ground and pound, they walked away and said, pick up your man. Well, they couldn't pick him up because he was dead and he was too heavy. They tried. Mr. Sin repeatedly said that everything happened in the dark. Well, we know that it happened, the actual end of it anyway, the punch that dropped Ethan and killed him happened under that light pole. It wasn't in the dark. It was under the light pole. And Lamarian was right there watching it. And Lamarian tells you Deshawn's the one who threw that punch. The cell phones, I mean, I guess you gotta try something. So what if you got the cell phones? It's like a red herring. You needed to know what was said before and after. Well, we could never see what was said after because all the phones were broken on the ground after. All three boys, and Ethan's was missing. But who cares what they would have said on a cell phone beforehand? Hey, let's go smoke some weed. Hey, let's go meet up. That has nothing to do with what they did. Nothing. So I'm not sure why that's even brought up. That seems to be just sort of a red herring. The Exhibit 2 that we had here kind of shows the school and shows where Ethan's body was found. And just look, as co-counsel called it, sort of the debris field of this altercation. You know, it starts up here, and there's a broken gun on the ground, right? It moves away as he's moving towards the lamp, which is here, and Ethan's getting further and further away from his friends in the car, and you got the broken part of the gun here, you've got his wallet, you've got his shoes that have come off during the fight. This shows, again, the intent here was not just, I'm going to punch you for shooting me with an Orbeez gun. The intent was and did cause serious physical harm. 2-on-1, 3-on-1. Not a fair fight at all. There was the instruction you heard about complicity. So basically, it doesn't matter who caused that final punch. If you were involved in the attack together, we heard that Deshawn's actually done fighting or assaulting Ethan, and he's walking away when Tyler calls him back over because he and Ethan are squaring up again, Tyler and Ethan's allegedly, and that Deshawn comes back over to get back in the fight as 2-on-1 again. Never a fair fight. It was never, ever a fair fight. So when you're looking at the force used, there's lots of different instructions on the force that can be used. But part of it is a definition of unreasonable force. A person is allowed to use force that is reasonably necessary under the circumstances to protect himself from an apparent danger. the state must prove beyond a reasonable doubt that the defendant used more force than necessary and that the force used was greatly disproportionate to the apparent danger. That's what we're submitting to you, that the force used is way over the top to qualify for self-defense. In deciding whether the force used was greatly disproportionate to the apparent danger, you may consider whether the force used shows revenge or a criminal purpose. And that's what we believe that this was. Retaliation, revenge by the defendants against Ethan. In the beginning, ladies and gentlemen, you saw and you heard repeatedly the Orbeez gun, right? This is what apparently this young man lost his life over, was a toy gun. Because they got mad, they got angry that they shot at them, and they went to fight him and retaliated because of a toy gun. You'll have it in the back, and you can look at it. You'll have the Orbeez little gel balls that are filled with water. I submit to you again, not self-defense, because they went way over the top. We are all responsible for our choices. Their choice was to walk over to Ethan and engage him in a fight that then went 2-on-1, 3-on-1. And I think I said it in opening, they may not have wanted to kill this young man. No, never said that. But they are responsible for their actions, which led to his death. And at the end here, ladies and gentlemen, I just want to thank you so much for your attention. I know it's been a really long day. The state feels that we presented the evidence that you can use to find the defendants guilty. And we ask that you hold them accountable. Because, again, we all make choices, even ones that are poor. And unfortunately, their choice to engage with Ethan, to continue to engage with Ethan, to fight with him across the parking lot, 2-on-1 and 3-on-1, caused his death. Thank you.
Thank you, Ms. Trickey. All right, ladies and gentlemen, at this time I'm going to give you a few more instructions, mostly related to your deliberations and how to conduct your deliberations. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media such as cell phones, telephones, tablets, computers, the internet, any internet service or any text messaging service, any internet chat rooms or blogs, websites such as Facebook, YouTube, or Twitter, to communicate to anyone any information about this case or to conduct any research about this case until after I accept your verdict. The fact that notes taken by a juror might support his or her recollection in no way makes his or her memory more reliable than that of jurors who did not take notes. All notes are confidential matter for consideration of the jury only, and all notes will be returned to the bailiff and will be destroyed when you are discharged as a jury. In your deliberations, you must not consider the subject of punishment. Your duty is confined to the determination of whether the defendant is guilty or not guilty. In the event that you find a defendant guilty, the duty to determine punishment is placed by law upon the court. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all the disputed questions of fact, to apply the instructions of the court to your findings, and to reach your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all of the evidence and make your findings with intelligence and impartiality, without bias, sympathy, or prejudice, so that the state of Ohio and the defendants will feel that their case was fairly and impartially tried. If during the course of the trial I have done anything that you might consider an indication of the court's view, you are instructed to disregard it. When you go into the jury room, your first function will be to select one of your fellow jury members as foreperson. The person you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than others. He or she serves the purpose of helping you conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict forms and the exhibits are returned to the court after you have reached a verdict. Your initial conduct upon entering the jury room is a matter of some importance. It is not wise to immediately express a determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position, even if you become convinced that it is wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after considering the case with your fellow jurors. Do not hesitate to change your opinion if you are convinced that it's wrong. However, you should not surrender honest conviction in order to be congenial or to reach a verdict solely because of the opinion of the other jurors. The court is going to place in your possession the exhibits that have been admitted during the trial and the verdict forms. As I have already stated, the foreperson that you elect will return them to the court. If and whenever you wish to view any of the electronic exhibits, the court instructs you that they must be played on a computer by and under the control of a bailiff or other person designated by the court, rather than by a member of the jury panel. Please make your requests accordingly. If you wish to view those exhibits, my bailiff will assist you in viewing those on a computer. Until your verdict is announced in open court, you are not to discuss with anyone else the status of your deliberations or the nature of your verdict. The ultimate aim of jury instructions is to help all of you as the jury, and a written copy of the general charge should assist you in that function and avoid most, if not all, questions during deliberations. Therefore, and as I have stated, I will place in your possession copies of the court's instructions of law for your use. If during your deliberations questions arise concerning my instructions, the law, or the evidence, I may, under certain limited circumstances, furnish answers to them. Any such questions should be reduced to writing by the foreperson, indicating specifically what is requested and must not reveal the status of your deliberations. The foreperson must also sign any such questions. You should then notify my bailiff using the buzzer in the jury room, and she will retrieve your question and deliver it to the court. Now, jurors sometimes ask to see transcripts, additional documents, or evidence. Please know that you will have with you all of the evidence and documents that have been admitted as evidence for your review, and you will not be given any additional documents or other evidence, and that you will not be able to review any transcripts of the testimony. After you have retired, select a foreperson, and whenever all 12, and I will repeat, whenever all 12 of you agree upon a verdict, sign the verdict forms in ink and advise my bailiff by using the buzzer in the jury room. She will then return the jury to the courtroom for the verdict. I'm now going to review with you the verdict forms. The verdict forms are in this orange folder. They should remain there and be returned to the court in the orange folder. There are 6 verdict forms. As we have discussed, there are 4 counts that apply to Deshawn Stafford and 2 counts that apply to Tyler Stafford. So you need to consider each of those counts separately as to the charge and as to the defendant. I'll go through the first one with you in a little more detail. There is a heading at the top. It says count 1, involuntary manslaughter based upon aggravated assault. This one refers to the defendant, Deshawn Stafford. And it says, we, the jury, being duly impaneled and sworn, do find the defendant, Deshawn Stafford, Then there's a blank and an indication, a direction to insert in ink either guilty or not guilty of the offense of involuntary manslaughter as approximate result of committing or attempting to commit aggravated assault. It goes on, we do so render our verdict upon the concurrence of 12 members of the jury. Each of us said jurors concurring in said verdict signs his or her name hereto. This, and there's a blank for the date that you reach your verdict, the day of September 2023, and then there are 12 signature lines for the 12 jurors who agree with the verdict form as it has been completed. So there's count 1, involuntary manslaughter as it relates to Deshawn Stafford, count 2, aggravated assault as it refers to defendant Deshawn Stafford, count 3, involuntary manslaughter based upon assault as it applies to defendant Deshawn Stafford, count 4, assault as it applies to Deshawn Stafford, and then count 3, involuntary manslaughter based upon assault as it applies to Tyler Stafford, and count 4, assault as it applies to Tyler Stafford. When you have reached your verdicts, fill out the jury forms as they correspond to your decisions. All members must sign the forms in ink, then signal the bailiff, and you will be returned to the courtroom to render your verdict. Counsel, any further additions or corrections to the jury instructions?
No, thank you.
Renew my objection.
Correct. Objection is renewed. All right, I do have 3 alternates. Ladies and gentlemen, you were selected to serve in the event of a misfortune to a member of the jury panel. At this time, it will not be necessary for you to serve further. However, you are not to discuss this case or tell anyone how you would have voted. You are not to investigate the case in any way. You will be released from that instruction after the jury has returned a verdict. So before you leave, I will ask that you give my bailiff your contact information for several reasons. First, if there would be an emergency, if an emergency would arise before the jury has reached a verdict, we may need to contact you and ask you to return to court. So until we have a verdict, you are still on call in case there might be an emergency. Also, my bailiff will notify you when the jury has reached a verdict so that you then will know when you are free to talk to other people if you would like to about the case. And also, since you've been here all week, you probably want to know what the ending is. So we will call you and tell you when the verdict has been reached. So when I dismiss the jury, if you would give your contact information to the bailiff, and then you may be excused for the afternoon. Ladies and gentlemen, it is just after 4 o'clock. I'm going to recess here momentarily for you to begin your deliberations. As we discussed at the beginning, we generally don't go longer than 5 o'clock, so between 4 and 5 is when we like to recess. It's also when the courthouse officially closes. It has been a long day. Your schedule at this time is now up to you. So you may take breaks, you may recess at your discretion. However, I would ask if and when you take any breaks that you just buzz my bailiff and tell us what your plan is, if you're going to take a 10-minute break or you're going to take a lunch break or whatever your plan is so that we know where everyone is. As I said, it has been somewhat of a long day. There are jury instructions, numerous exhibits, and some important issues to deliberate. So if you would like to begin your deliberations now, I would suggest that you pick a jury foreman and then kind of collectively make a plan as to how you would like to proceed. If you would like to get started for the next hour or so, you may do that. If at this time you would like to recess and return tomorrow morning, that is acceptable as well. But as I said, just kind of let us know what your plan is. Once we recess, after a few minutes, you will get delivered to you all of the exhibits in this case, as well as numerous copies of the jury instructions so that you can refer to those during your deliberations. And one last thing, tomorrow, if we return in the morning, again, you can decide if 8:45 is too late for some of you or too early for some of you. You can decide when you would like to return tomorrow morning to begin. But you will not be in my jury room. There will be other proceedings in this courtroom tomorrow. So before you leave, my bailiff will show you where you should report tomorrow morning for those deliberations. Anything further from counsel? And once again, obviously there has been continued media coverage here, so you are once again instructed that you are not to view any media, avoid any media related to this case.
All right.
So we'll let you know when the jury's going to come back once. Do your whole 29. Oh, God, we're dealing with okay. Counsel, please step back. Here for a second.
All right, got it. You got 1 second, Mr. Gannett?
Thanks.
You know what's up with the judge?
I think you guys have been told tomorrow at least lunch or
But we gotta be here, so
stay close.
No, what time?
tomorrow we want to be here at 9 a.m.
9 a.m.?
Yeah. And even if you're not in the courtroom, just check with me. I mean, we gotta be close by, so you check with me when we get down here, we're in tight.
Okay.
Good night, guys. Thank you.
Thanks, everybody. Thank you.
All right, guys.
Okay, I just wanted to know. Okay, I got the shot of the clock ticking away. All right, just one for sure. Thanks.
that little envelope from you, the.
DNA evidence, I would think. You might clear some cases.